Because your lordship on last occasion directed to personal appearance of both the parties.
Reach Karu. Dekhiya, we have to know what for it was adjourned and what is the development in the meantime. And both parties have been directed to appear personally. So please wait.
We are ready for
It will
that.
be reaching, just wait.
Obliged.
May I please?
Yes.
You are challenging the order of the passed by the presiding officer,
Subuni, mic record.
presiding officer, Labor Court, my lord, Jaipur, my lord. By directing the management to
File colleague original.
my lord.
Communicated copy kain?
Well, I have file
Where is that?
the noting.
No, we don't find here.
Noting is there, my lord.
No. Same thing. Same thing. No, that is not there.
Noting of the certified copy file.
Sir, where is the certified copy? They just put a noting.
Put logele.
ସେ ରଖିଲେ କଣ ତାଙ୍କ ଘରେ ରଖିବେ ସାର୍ଟିଫିକେଟ କପି ଯଦି ଲେଖିଲେ it has been reinserted. And you are for the corporation
My lord.
management.
My lord.
What was the reference?
My
It's a
lord.
two-way reference.
Two-way reference.
Two-way reference.
My lord.
Then what was the reference?
Two-way. My lord. Sorry, I could not follow.
What was the reference?
What was the reference is the query by my lord.
Tribunal को reference कौन हितला?
My lord, for reinstate of
अरे reinstatement on account of what?
my lord,
Is
the
he claiming illegal termination?
yes, my lord, illegal termination.
So reference टा हमर केंति आपण industrial adjudication against करूचंदी case reference टा कोई पर नान केंति कोड at least reference has been taken note.
My lord.
अच्छी लिखने Industrial dispute proceeding re ID case award against habo. The very relevant thing is if it is a 10-2, if it is a 2A, if it is a 33C2,
not a 2A, my lord.
2A, then the tribunal, there is no reference here.
No, my lord.
But tribunal must have framed an issue.
Yes, my lord.
Okay, so that is what is that issue?
17, my lord. Issue as my lord.
According to para 4. Para 4 of the award.
My lord. Whether the action of the district manager.
Whether the action of
the district transport manager, administration in charge, Odisha State Transport Corporation, Barampur.
Allegation is refusal of employment.
My lord.
With effect from so and so. Then what is the outcome?
My lord, reinstate of the service, my lord, with minimum daily wages. Last page, my lord.
Client has fallen to unfortunate hand. Our query is what is the outcome?
Outcome, my lord, the termination declared as illegal.
So answer that way. Termination having been held illegal, there is a direction for reinstatement. With
my lord, minimum daily
with back wages. Na kaun kola?
My lord, full back wages.
Full back wages. All right. So what was your plea in the tribunal?
Please, my lord, the present petition of
Where is the written statement?
written statement. I have not filed.
देखो तो केमती आपण फाइल करूचंदी रीट पिटिशन डिसाइडेड खोजिबे आपनको प्ली कोन ask us to go to the discussions on the plea of the party. He might have left something.
He has, my lord, all discussed.
So whose responsibility? Should you bring the statement of claim?
My lord, I will, my lord.
Should you not bring the written statement?
My lord, I will,
To give a clear, it's a management case. Listen. Days have gone. जेतोले कि आसिला जदि इंडस्ट्रियल डिस्प्यूट आवर चैलेंज कला एडमिट कर दियो कॉल फॉर कर दियो एलसीआर. Those days have gone and 17B will automatically follow. So you must be satisfied that you have taken a strong ground or strong stand which has not been properly considered. Then only we will admit. केते वर्ष हेलानी से लोक को वर्तमान
my lord,
से लोक को वर्तमान केते वर्ष हेलानी किछि नथु आपन पाखरे. मिस्टर त्रिपाठी प्लीज.
my lord, in the,
अब बयस तो लिखा है नहीं कौन
बयस
देबे.
लिखा
आपण भी केयरफुल हेले नहीं. तार स्टेटमेंट ऑफ क्लेम रे से डेफिनेटली एफिडेविट करथिवो कि वेरिफिकेशन करथिवो ता बयसटा लिखिथिवो आ 5 वर्ष अछि कि 3 वर्ष अछि तेनु आवार्ड रु आ 2 वर्ष चाकरी करथाई पारे. किति जिंस कंसीडरेशन अछि. Come better prepared.
my lord.
Matter be called on next Tuesday. Counsel, Tripathi counsels of the petitioner is directed to bring here the copy of the statement of claim as well as the statement of claim, written statement of the statement of claim by workmen, written statement by management. So also the copy of the evidence.
Sir, I am for the respondent too. Sir, I am for the respondent too. Workman, sir. Workman is at the age of 43 years. After the passing of the award,
So if you enter into contest, then let us admit. We are not
Yes,
yet
sir.
satisfied. We are not yet satisfied whether matter will be admitted or not. You want to contest the matter by appearing.
no, sir, I filed the caveat.
Mr. Mishra,
Sir,
caveat lodge in. And kindly be patient. Apano bodhe subhi nathibo what fell from my lord. That we are only hearing on the admission matter.
We are still struggling for admitting matter. ଆପଣ ଆସିଲେଣି ଆର୍ଗୁମେଣ୍ଟ କଲେଣି ମୁଁ 25 ବର୍ଷ ଚାକିରି କରିଛି 20 ବର୍ଷ ଚାକିରି କରିଛି ମତେ ଦେଇ ଦିଅନ୍ତୁ ଆଜି who will be allowing the dispute now.
Next
Please have patience. Next Tuesday.
ଆପଣ next ହଉଛି 25 ତାରିଖରେ ଆଉ ଥରେ ଆସିବେ ଭିସି.
sir.
Yes.
Sir.
ଆପଣ ବି ଦିଅନ୍ତୁ ଆପଣଙ୍କ statement of claim and evidence.
Okay, sir.
ଆଉ
Okay,
written
sir.
statement ର କପି ସବୁ ବଞ୍ଚ କରିକି 2 sets ରେ ଫାଇଲ କରନ୍ତୁ.
Sir.
ଆସିବ next Tuesday. Yes, next.
Item number 2. Item number 2, my lords.
Mr. Tripathi, next date we will be hearing you on the strongest ground available. One ground you will raise to satisfy us.
My lords, it was my lords listed earlier. My lords, there was a direction to give that certified copy of the order in Annex 3. That is order of the GRF. Yes, we have already given Annex 3 and Annex 7.
Yes.
The free copy.
My lord, I am appearing for opposite part number 4.
Pagination ହେଇନି ଆଉ ଥରେ କରିଦେବେ noting ଆସିଛି.
हाँ, pagination out there. The accept ହେଇଗଲେ ମୁଁ ତ
Young
unless
counsel should know all
my
these
should be
things.
pleased to accept it so that.
The learned, young counsel who
Maybe-
is appearing along with you should know all these things.
Yes, ma'am, that
I mean,
situation
he is not
changes.
to,
Kindly maybe
As a
directed
deputy
to
tomorrow.
give copy opposite part.
ଆପଣ ଯୋଉ ଚଷମା ପିନ୍ଧୁଛନ୍ତି dismiss କରିଦବୁ. ଆପଣଙ୍କର ଏଠି ଆସନ୍ତୁନି ଆପଣଙ୍କ brothers and sisters ବସିଛନ୍ତି ଆପଣ ଚଷମା ପିନ୍ଧିକି
ଆପଣ
ଆପଣଙ୍କ ଅପରେସନ କରିଛନ୍ତି ନା
ବସୁନାହାନ୍ତି।
conjunctivitis?
Copy, I want copy.
ଆଖି କଥା କହୁଛନ୍ତି।
ଆଖି ଧରିଛି କି?
ନାହିଁ ମୁଁ କେବଳ
ତ ଆସନ୍ତୁନି ବର୍ତ୍ତମାନ ମିଶ୍ର ମହାପାତ୍ର କାଲିଠୁ ଫେର ଚଷମା
one week or later
There is already filing of original of the impugned order. Office to verify and
Allow
accordingly paginate the brief, repaginate the brief. Yes.
For orders, item 3,
On the last occasion, your lordship directed to call for LCR and requisite already filed.
That's it. So you will take fresh notice. Door was locked. Door was locked, so you have to take, and there is also no appearance by anybody. So notice the issue, admit he said, see, okay. Matter has already been admitted with calling for LCR by the order of this court dated 15/5/23. There is stamp reporting of non-service of notice on the ground of door locked. Address is door locked. Counsel for the appellant is directed to take fresh steps for issuing notice on the admission notice, issuing notice on the respondent herein. Refugees, as undertaken, be filed by day after tomorrow. Okay, unserved copy may be utilized.
Return date will lordship. Return date will lordship fix up.
And return date matter will be listed immediately after the appearance of the. So if the address is changed, then ଆମେ ଅଧିକା ସମୟ ଦେଇ ଦଉଛୁ ହେଲା by Tuesday କରିଦିଅ. If there is change in the address of the respondent, Planet Counsel is Das is directed also to.
पैन को पचारंतु वाइफ कोर्ट रोचंती तो घर काट देले ताको निज एड्रेस तो नहीं परिबेनी बटर से कोड बाप घरे अछन कि भाई घरे अछन
से रोच इंटेंशनली रिसीव करना
इंटेंशनली कोन आगे सेटा कोन जुडिशियल रिव्यू करता वेदर डोर लॉकडाउन
In that event, Mr. Das, maybe you have to go for paper publication there.
Yes, ma'am.
If you want early hearing, be careful. आणंतु address आणंतु.
Okay.
नाइ जदि न आणंतु कोर्ट को रिक्वेस्ट कर दियंतु order 5 rule 20 पळेवा पेपर पब्लिकेशन कर दवा.
Yes, ma'am.
काना सी जहा कहउछोदी my learned brother, if she is driven out from the house,
Yes, sir.
she might be taking shelter somewhere who you may not be knowing, brother may not be knowing. So it may be difficult. So on the next date, if you don't find correct address, then bring up.
My lord, I have already filed the correct address, but intentionally is not received. But
अरे आपण जोटा कहउछनी सेटा ए नोटिंग रे कोन आमे ताको रिव्यू कर परिबो
no.
तले सेटा समस्त काहे कहते मु बुझी पारेनी
ताले
इंटेंशनली कोनांदी आपण एफिडेविट
फाइल करंतु
तापरे एटा दिस लॉ डोर लॉक जोटा सेटा एउटा थर्ड पार्टी
Yes.
से होचनी पोस्टल डिपार्टमेंट ही सेटा से तो करन
ना ना
देबनी
ना
सेटा तार किसी स्कोप नाही
if you will not appear.
कोन लाभ हो से परे गोटे एक्सपर्टी सेटिंग असेट ऑफ एक्सपर्टी फाइल करियो
Yes.
So gala every effort goes. Every effort goes. So କରନ୍ତୁ ଆଣନ୍ତୁ being
ଆଜ୍ଞା.
appropriate application ଆପଣ ଯଦି find କରୁଛନ୍ତି ଯେ ସେ deliberately avoid କରି then you may come up
ही
with
पारे
it.
ही पारे आपण जोटा
ହେଇପାରେ।
कहउछ सेटा बट यू हैव टू मेक एन एफर्ट जे जेमती जोदी ता कोनकर ता घर के जॉइंट लिविंग ये थिबे सेठी नले नै जिवे से जोटी रहउचंती
Last fresh address.
देखो only thing is that all substituted services has become very costly.
Precision 4 रे yes 4 call करते
Okay.
4 डाको.
item 4, may please.
This is an application for change of the nomenclature of the present appeal from MATA to GUAP. Okay, considering the necessity, this court allows the application. For me to register, to convert the MATA to GUAP, have stress stamp reporting and list the matter in appropriate assignment.
Obliged.
For addition item 5,
My lord. I am for the appellant. I am for the appellant. File a case for entry maintenance, my lord.
This is by wife
My lord.
who appears for the husband.
Yes, I am appearing for the husband.
You are there.
Yes, my lord. Maintenance has not been paid
So
since.
this has come for final hearing. And
Maintenance
what is the interim proceeding there? Interim maintenance with its objection.
ସେଟା ଦଉନାହାନ୍ତି ସେ 2020 ରୁ ଦେଇନାହାନ୍ତି.
There was grant of interim maintenance
yes,
by
ma'am.
this court.
Yes, ma'am.
And then what is the petition pending?
The interim.
What was the interim maintenance directed? Order dated 9/2. 9/2. For somebody else, because there is already an order not to list before Honorable Justice V. Prasad and Biswanath Rath. So I can't hear this. By order dated 11/7/16, there is the following direction has been passed. The registrar
Lord.
should have been careful in listing the matter.
Initial or change.
Okay, matter stand released. Rest is directed to obtain instruction from Honorable Chief Justice for listing in a page other than Biswanath Rath J.
ସେ ଲୟର ତ ଚେଞ୍ଜ ସେ ଫାଷ୍ଟ ଯେ ଲୟର ଆପିୟର କରୁଥିଲେ ସେ ଚେଞ୍ଜ ସେ ତାଙ୍କ ସାଙ୍ଗରେ
ଆଗରୁ ମୁଁ appear କରୁଥିଲି।
ନାଇଁ ନାଇଁ ଯିଏ ଥିଲେ ଫାଷ୍ଟ ଲୟର ମିଷ୍ଟର ପଣ୍ଡା ସିନିୟର ଆଡଭୋକେଟ
କଣ ହେଇଥିବ ମୁଁ
ସେଠି
ମନେ ଏତେ
ସେ
ଦିନ
ଟିକେ
ପରେ।
Item 6.
Filing an authorization memo, my lord, to appear on behalf of my lord,
Pardon, you are appearing.
my lord.
Appearance memo of so and so we kept on record.
My lord, I am appearing for the respondent, my lord. I am filing my Vakalatnama, my lord.
You are for today you are appearing for
Yes, ma'am.
respondent. All right, appearance of counsel for respondent we kept on record. Next listing, if any, should indicate the name of the counsel for respondent. So this has come for final hearing.
My lord. And not admitted, my lord, it is not admitted.
Not admitted.
Not, ad-
There is a noting, my lord. So, pardon, you are in which matter?
my lord, I am for the appellant, I filed the
Serial
authorization.
number?
6, my lord.
6.
I have already filed the authorization memo. my lord.
Serial number 6 ରେ ଆପଣ ବି appear କଲେ fresh appear କରୁଛନ୍ତି।
Authorization, authorized by the council. for the-
right, ଠିକ ଅଛି, after taking consent of the other council, ଏଟା appellant ପାଇଁ ବି ଉପରେ ଲେଖିବ, there is appearance of new set of council, of course taking consent of the previous councils, ହେଲା। Registry directed to take note of the fresh appearance and indicate names of the fresh councils accordingly. Admit ହେଇନି?
I,
Yes, all right. Who are you? You are the husband or wife?
I am the mother and the children of the first wife, and the respondents are claiming to be second wife.
Then how it is, what is the matrimonial?
We have filed a petition before the family court,
Who has
to-
filed?
the appellants.
अरे appellant टा किए?
The mother of the deceased is one deceased Surendra
Mother?
Malik.
Mother of deceased son
Surendra Malik, my lord.
and
And the children of first wife,
children तो दीटा child अछंती।
yeah.
Two sons of the
deceased.
deceased.
And the appellants are claiming to be second wife and their children or children. Respondents are claiming
Second
to be,
wife and the outcome
yes.
and the blessed children thereon. Then what was the claim with here?
The appellants filed the petition for a declaration that the Respondent number one is not the wife of the deceased Surendra Malik. And
Was there earlier divorce?
no, the first wife died before the death of the Surendra Malik.
Or dead ହେଇଯାଇଛି?
Yeah. Tapare his second wife, their second wife claiming to be the second wife, she filed an application for legal heir certificate. And after that certificate, there was an
Okay.
appeal.
Right. You have come as against rejection of a order.
Order of
Order 7 rule 11
Allowing order 7 rule 11.
no.
rejected.
Yes.
Yes, my lord. Order 7 rule 11 petition was allowed and the suit was dismissed. On the ground of there is no cause of action. The respondents appeared in
Suit
the
has been
suit
dismissed.
and filed order 7 rule 11 which
So
was allowed.
proceeding has been finally terminated.
Yes, my lord.
On the ground that the dates of the cause of action were not furnished.
That's it. I'll admit for you. That is admit. Yes, admit. Since. No, CPC for the civil court. Call for LCR in civil proceeding 5 of 15. Okay, since there is already appearance on behalf of the respondents, all respondents.
Yes, ma'am.
Respondents. So Sri Ponda, Manoj Ponda
Yes, ma'am.
and associates. 2 extra copies be served on the council for respondent as undertaken by Friday.
My lord.
By Friday. कौन मिसकेस किसी अच्छी की मिसकेस कौन पे
My lord, miscase filed, my lord.
एटा तो डिक्लेरेशन पे खाली थिला
My lord.
so there can't be any miscase
That there was a delay, my lord, that
any distribution of money eso किसी अच्छी की
my lord, not to release the retirement benefit of the deceased employee.
Huh?
Surendra. Not to release the
Huh.
retirement benefit of deceased Surendra Malik, who was a government employee.
ये तो एप्पल तो रिलीज होतुवा ट्रायल कोर्ट रे किसी इंजंक्शन थिला
My instruction was ହେଇନି.
इंजंक्शन जदी नाही ताले whatever release will be subject to result
ଆପଣ agree କରିବେ କି apportionment ପାଇଁ?
My lord, that conciliation ଯଦି କରିବେ ସେ.
ଆପଣ ମାନେ ରାଜି ହେବା ଦରକାର ନା ସବୁ ତ conciliation fail କରୁଛି.
My
My lord,
That-
since it is a pension matrimonial paper dispute, pension may paper refer the exhibit matter କରିଥିଲେ। for mediation, my lord. Pension paper exhibit ହେଇଥିଲା କି କାହା beneficiary କାହାର ଥିଲା ଯୋଉ joint Pension photograph? paper, my lord, wife, the present respondent number 1 is the nominee. But you are not disputing that she is the legally married wife. ଆପଣ କୋଉଠି dispute କଲେ order 7 rule 11 petition? My lord, she claiming the first wife who has died in 1997.
that's right on
Sir,
death
ତାଙ୍କର surviving legal heirs ଅଛନ୍ତି ନା? Yes, my lord. I am not disputing their the legal heir. my lord. I am not disputing their legal heir.
तो ସେମାନେ ପାଇବେ ପଇସା
My lord,
apportionment ହବ
they are entitled to the interest, my lord, the amount, my lord. Yes, Interest amount pension ରେ କଣ ମୁଁ ବୁଝି ପାରୁନି actually. my lord, yes. ଆପଣ pension ରେ dispute ଅଛି ଟି? Pension, ହଁ family pension କିଏ family receive pension. କରିବେ? Family pension will entitle by the
Retirement
wife, my
benefit.
lord, and the
retirement benefit as well as pension
benefit, yes, my lord.
दीटा आगरे
Gratuity That चाहिए will be apportioned between the parties, my lord. Gratuity and other benefits.
तापरे हमें consider करिबु
Yes, my lord.
but please bear in mind
Yes,
he undisputedly the first party here the appellants
mother of the deceased
mother
and
and the two
two
children.
sons of
Therefore,
the
you
deceased
can't
employee.
take away their right.
Yes, my lord. I have not objected their
So
right.
therefore be benevolent.
Rather, they are objecting our right.
Be
So we have.
benevolent. Release बर्तन pattern decide करिबा
Yes,
both sides survive
Yes.
तापरे final hearing करिबा जा हबो
ଦେଖିଛନ୍ତି both of you?
Who are
Yes,
the
ma'am.
entitled? ଦେଖନ୍ତୁ provision and
ଆପଣ-
retirement ରେ
ବେଳେବେଳେ ଆପଣ ଭାବିବା କଥା ଯେ କାହିଁକିନା ମିଷ୍ଟର ପାଣି they are both ଇଏ major son ଏପର୍ଯ୍ୟନ୍ତ ହେଇନାହାନ୍ତି unmarried daughter ଯଦି ରହିଲେ
Yes, ma'am.
ସେ ପାଇବେ
କିଏ ପାଇଯିବେ?
and what about mother? She is 78, she
Yes.
was 78.
Now 80, more than 80.
So whether how she is entitled or not? So ultimately କଣ ହବ ନା it is like this ଯେ ଆପଣ ମାନଙ୍କର କାହାର ପାଇବାର ନାହିଁ ହକ୍ ସିଏ କ୍ଲେମ କରିକି ତାଙ୍କର ପେନସନ ପେପର କରିଦେଇଛନ୍ତି ମୋଷ୍ଟ ଲାଇକଲି ତାଙ୍କର ବଳ ହଉଛି ଯେ ସିଏ ଗୋଟେ ପେନସନ ପେପରରେ ଦେଇଦେଇଛନ୍ତି ତାଙ୍କ ଫଟୋ ଆଣ୍ଡ ବେନିଫିସିଆରୀ
Substitute କରିଦେଇଛନ୍ତି।
କରିଦେଇଛନ୍ତି ଆପଣଙ୍କର ମାନେ କ୍ଲାଏଣ୍ଟଙ୍କର ଯୋଉ ବୋହୂଙ୍କୁ ସେ କରିନାହାନ୍ତି ତେଣୁ ଯଦି ଆପଣ ମାନେ କେହି ପାଇବେନି ତାହେଲେ ସେ ପାଇବେ that you have to be to that extent but without ମାନେ prejudice to all your claims
Yes.
problem ହେଲା ଆପଣ ଭାବି କହିବେ ଯେ ସିଏ ଯଦି ୱାଇଫ ବୋଲି ଥରେ ଟ୍ରିଟ ହେଲା ତାହେଲେ ସବୁ କଥାରେ ସେ ପଶିବେ that is your concern
That is all.
ସେଥିପାଇଁ ଆପଣଙ୍କର କାଉନସିଲିଂ ଦରକାର ଆପଣଙ୍କ claim।
Yes, ma'am.
ଦି ଜଣ ଯାକ ବସିକିରି
Madam.
କନସେଣ୍ଟ କରନ୍ତୁ
Madam.
ହେଲା ଏଗ୍ରି କରନ୍ତୁ ଟୁ ସର୍ଟେନ ଏକ୍ସଟେଣ୍ଟ ଆମେ ତାକୁ ରେକର୍ଡ କରି କ୍ଲୋଜ କରିଦବୁ ସୋ ପ୍ରୋସିଡିଂ କ୍ଲୋଜ
Well, that will be better since they are have.
we are placing it 3 weeks after
Yes,
Madam.
ma'am.
matter may be called 3 weeks after both counsel prima facie agreeing to come up with some sort of settlement to resolve the dispute between both parties by next date. Let the outcome, if any, be intimated by way of joint affidavit before the next date of posting.
Madam.
3 weeks a date. It is better soon the
Madam,
demand kale bhi kon hobo.
Madam.
Ultimately, question of entitlement will come. Major son egala se kichi paiba. Retirement dues re, if one can go to the extent stretching it to be the property of the father. So property of father re hue to puo di jana paiba. Man rakhandu.
Madam.
Man rakhandu.
Madam.
Property of father re puo di jana pai paribe. Mother will also be entitled for sustenance.
Again.
ସେ ସେୟାର ନ ପାଇ ପାରନ୍ତି କିନ୍ତୁ ତାଙ୍କ ସଷ୍ଟେନେନ୍ସ ପାଇଁ ସେ ପାଇବେ ଏଇ ତିନିଟାକୁ ମାଇଣ୍ଡରେ ରଖିକିରି ଆପଣ ଆସନ୍ତୁ ପ୍ରପୋଜାଲରେ ଉଭୟ ପକ୍ଷକୁ ବସାନ୍ତୁ ବସିକିରି ଆଣନ୍ତୁ ଏଠି କ୍ଲୋଜ କରିଦବା
Aye.
40-60 କି 30-70 ଯାହା ରାଜି ହେବେ ହେଲେ litigation battle କରିକିରି ଲାଭ କିଛି ନାହିଁ
ଆପଣ ପେନସନ ଯଦି ପୁରା ପାଇବେ ଜୀବନ ସାରା 34 ନା କେତେ ହେଇଥିଲା
ହଁ, sacrifice
ଆପଣ ଭାବନ୍ତୁ
this-
ଆପଣ ସେ ଏପଟଟା
Madam, I am ready. That is why I am submitting
ଆପଣ
that we are entitled
ପେନସନ
the
ଯାହାର
proportionate
ନଉଛନ୍ତି
share in.
ଆପଣ ଯାହାର ପେନସନ ନଉଛନ୍ତି ଆପଣ ଫ୍ୟାମିଲି ପେନସନ କାହିଁ କୁହାଯାଏ ତ ୱାଇଫ ପେନସନ କୁହାଯାଏ
My lord, my lord.
ଆପଣଙ୍କ ଫ୍ୟାମିଲି ଆପଣଙ୍କ ବାଟରେ ସିଏ ମା ପୁଅ ନା ମା ନା ମାନେ ତାଙ୍କ ପିଲାମାନେ ସିଆଡେ ଅଲଗା ରହିଲେ
My lord, I am conscious that I am.
please have that approach
Yes, ma'am. Yes, ma'am.
ହେଲା
I will talk with my friend.
we are hopeful we have
Yes.
sent sufficient indication
Yes, ma'am.
so come up with a good proposal
Madam. Oblige your lordship.
Yes.
Item 7,
କିଛି ନାହିଁ ମାନେ ଚାଲିବ litigation ଚାଲିବ ଓକିଲ ପଇସା ହେବ କିଛି ହବ
Item 7, may please your lordship. As per last direction, my lord, the wife appellant, may please your lord. As per last direction, my lord, the wife appellant wife is present today in the court in person.
ଡାଇରେକ୍ସନ କଣ ହେଇଥିଲା ମାସ୍କ କାଢି ଦିଅନ୍ତୁ
ଆଜ୍ଞା
ଶୁଭିବନି କଥା ଠିକ ସେ
ଆଜ୍ଞା ନାଇଁ, ମତେ ସିଭିୟର କୋଲ୍ଡ ହେଇଛି ବୋଲି ମୁଁ ନିଜେ ପିନ୍ଧି ଦେଇଛି since I am suffering from severe cold so I have put it on
cold ତ many of us are suffering from
my
cold
lord because of the weather
କୋଉ ଡାଇରେକ୍ସନ ରେ ହେଇଥିଲା ଆସିବେ ବୋଲି ସବୁ?
5/7/2023 there are before 3-4 directions were there she didn't appear the lordship directed on 5/7/2023 not for personal appearance but with a direction that
Okay, 10 days after for considering the request of the learned counsel for wife to have an attempt at their one side for some sort of settlement at their side do
My
it.
lord.
One
My
side.
lord, the wife is present in person, my lord. Wife is present in the court, my lord, today in person.
You are for husband.
I am for the wife, my
You
lord,
are for the
appellant,
wife. Mr. Mishra is for husband.
my lord.
What was the direction involved here?
my lord your lords
Divorce has been allowed or?
Allowed, my
my
lord. In Tribal, divorce has been
And
allowed. Filed
payment
by
is
the
2 lakhs.
my
my
lord
Payment is 2 lakhs.
कौन मिस्टर महापात्र मेंशन
Yes,
करले
yes, your lordship. Item 8, your lordship, the conducting council Miracos has been expired, your lordship. In the
आपण आगो
meantime,
ऑर्डर गुडा को जोटा पर्सनल अफेयर्स डायरेक्शन हेतिला सेटा टे रेफर करंतु पण
Se-
स्टेट जो आरंभ करचोंदी हमर बैकग्राउंड जानिबा हमें दरकार आपण कोन चाहुचोंदी
your lordship actually.
आपण
I have-
19/4/23 रे आपण विथड्रॉ कले पावर
No, your lordship, I have not filed my
अरे
वकालत
सर
number.
आपण बुझ पर आपण टिके 19/4 ऑर्डर रे पारा 5 देखंतु
ସେଇଥିରେ ମୁଁ actually power ଟା file
ମୁଁ
କରିନି
ଏଟା
only
modify
as
कर
per
दो
the
ऑर्डर आपण
instruction.
सेटा कोन करिवे ना फिर तार प्रतिकार करिवे ना नहीं
Maybe-
हमें जहां पारिबु कहि दबु
No, your lordship,
In the meanwhile, Mr. J.K. Mahapatra, Lord Counsel,
Yes.
may file the deed of power of the respondent, may engage any other counsel for representing her.
I have not filed my वकालत number, your lordship. Only as per the instruction I
Sir,
have received.
ମାନେ ଆମକୁ ସେଟା ପଚାରୁଛି କି ଆପଣଙ୍କୁ?
No,
There is an order by a division
yes,
bench.
I found that.
So para 5 रे यह लिखा है
हाँ.
you are Mr. J.K. Mahapatra.
Yes,
Lord Counsel may file the deed of power or the respondent may engage any other counsel for representing her. Order number 10 dated 19/4/23.
And next date is non-appeals for the appellant.
yes, I
So
have.
power is not coming.
No, your lordship,
You
because
don't have power even today.
we could not contact to the
And
wife. your lordship.
forget that. Let us dismiss the matter for non-prosecution because there
No,
is
I
no
am for
power.
the-
Already 2 dates have gone. If power comes, you file restoration.
Your lordship, day after yesterday, I have intimated to the.
ये respondent पे
हाँ, respondent पे से मुझे कहले मोर
कुर्सी
I'm on behalf of
I
Mr.
have
Arup
taken-
Chandra. I'm appearing.
Arup Chan.
Yes.
So what do you say? What do you want?
I
आपण
have
भी
a-
adjournment चाहते
I need adjournment because he is ill, he is suffering from serious illness.
Both parties not showing interest.
ଆପଣଙ୍କର ଏପର୍ଯ୍ୟନ୍ତ ପାୱାର ନାହିଁ
What happened, your lordship?
ନାଇଁ
kindly-
ସାର୍
kindly
ଆପଣଙ୍କର ପାୱାର
permit-
ଅଛି ନା ନାହିଁ
No, your lordship.
ତାହେଲେ ସର୍ଟ ଇଟ୍ ଆଉଟ୍ ଗୋଟେ
ତାହେଲେ-
ଅକରାଧନାମା
Yes,
ନେଇ ଆସନ୍ତୁ
For a,
ଫାଇଲ କରନ୍ତୁ
for a
memo
moment,
ସହିତ
your lordship, kindly
So
may
that
be
can be taken on record.
may permit, your lordship, for a moment.
Counsel for petitioner.
I have informed to the,
permitted.
your lordship, I
Sir,
have
ମୋର
already,
response quick ବୋଲି ଭାବୁଛନ୍ତି ମୁଁ ବୁଝିପାରୁନି ନା କଣ
The respondent as of now. 2 dates have lapsed. There is no improvement in filing the power of the respondent. Be that as it may, the matter stand adjourned. The matter stand delisted for the petitioner not showing interest. Appellant not showing interest. କିଛି interim order ଯାହା ଥିବ ଥିବ ଆଉ ଅଛି କିଛି interim order.
ଆପଣ ଡିଫିଡେଣ୍ଟ କାଇଁ ଫିଲ୍ କରୁଛନ୍ତି ମିଷ୍ଟର ମହାପାତ୍ର ବି
No.
କନଫିଡେଣ୍ଟ
yes,
you can request any of your elder brother to appear along with you
your lordship,
ଆପଣ ଡିପେଣ୍ଡେଣ୍ଟ ଫିଲ୍ କରିକିରି ସେଇଟା ଗଲାଣି ସେ କେତେ ଡେଟ୍ ଗଲାଣି
ନା
ଫାଇନାଲି ଆପଣ ଗୋଟେ ଜାଗାରେ କହିଲେ ଯେ ପାୱାର ନାହିଁ ବୋଲି
ସେ ୱାଇଫ ସହିତ କଣ୍ଟାକ୍ଟ ହେଇପାରୁନି, your lordship.
ସେଇଟା
That is the
କୋର୍ଟର ସାର୍ କୋର୍ଟର ସେଟା କିଛି ଅଛି ରୋଲ କରିବାରେ
No.
ଆପଣ ଯଦି କହିବେ ଯେ କଣ୍ଟାକ୍ଟ କରିପାରୁନି କ୍ଲାଏଣ୍ଟ କୁ ଦ୍ୟାଟ୍ ଆମାଉଣ୍ଟସ୍ ଟୁ नो ଇନଷ୍ଟ୍ରକ୍ସନ
Both the matters released.
Item 9,
Oh, bless.
Yes, item 9.
Let's say we are praying for filing a detailed affidavit so that the adjudication of the case should be.
Was there any direction?
No, there are
Was there any direction for filing an
There-
affidavit?
no there is no direction.
So then what affidavit you will be bringing? This is an appeal.
May I just clarify one thing, my lord? During the course of the previous hearing, it was noticed that in the connected.
Supune,
During the course of hearing, it was noticed that in the connected DV case, the husband has admitted that he has married.
benefit of both sides. Okay. Counsel for the Sri Parikh, learned counsel for the husband, while not disputing that his client has already gone engaged with another girl in the meantime, making clear statement that the further engagement with the wife possibly taken place within 1 year of the marriage. However, doesn't deny to have taken compulsory retirement, voluntary retirement, and there is some earning in the process to the husband. The Shri Barik also request this, in this circumstance, Shri Barik request this court for grant of some time to come up with concrete proposal. Considering the rival contentions of the parties, this court direct the of the respondent herein to bring an affidavit with clear disclosure of the properties belonging to him, so also properties belonging to his family members, parents, particularly the parents, along with clear averment and document, at least enclosing copy of the passbook statement in receipt of the final retiral dues on the voluntary retiring of the petitioner. At least all this, let the affidavit be filed at least within a period of 2 weeks with service of copy to the other side. Place the matter for a 10th of August. So you have understood. So voluntary.
Passbook, public bank statement.
And bank statement of the annual bank statement of the year involved. ଆପଣ ବି କ୍ଲାଏଣ୍ଟ ସାଙ୍ଗରେ ବସି କଥାବାର୍ତ୍ତା ହୁଅନ୍ତୁ, ତାଙ୍କ ସାଙ୍ଗରେ ବି କଥାବାର୍ତ୍ତା ହୁଅନ୍ତୁ, କଣଟେ ହେଲେ ଯୋଉଟା କି ଆମେ ରେକର୍ଡ କରିବା, ଆପଣ ଯିବେ ପିସ୍ ଆଉ ମ୍ୟାଟର ରହିଲା ଆମେ ବି ରାଇଜ କରିବା 12ଟା ବାଜିଲା। ଆଉ ଯାହା ମ୍ୟାଟର ସବୁ ରହିଲା କାଲିକି ଆସିବ। ତୁମର ଗୋଟେ କାମ କର, ଜଷ୍ଟ 1 minute, ଯଦି ମାଟା କିଛି କାଲି ସ୍ପେସିଫିକାଲି ଫିକ୍ସ ହେଇଛି ତାହେଲେ ଆସିବ ହେଲା, otherwise these repetitions will hear tomorrow.
Again, that 11 item 11. First one in the writ petition. Tomorrow I have some personal inconvenience. I have to prefix matter. Can be next any day next week, your lordship's convenience. I have, or maybe even day after tomorrow, Friday also.
Panic after Friday. Next Wednesday,
Tuesday.
On the request of Sri Hon'Ble and his senior counsel. Intimate other side counsel also.
He's on VC.
All right. Upon Putre mention.
My lord, item 10. Interim order is there till next date.
You rest assured, wherever interim. Upon Jani Rokandala, Jota Arjan, interim order will definitely continue.
My lord, item 10, my lord. I am for the
item 10 that deal with Asiva.
2 weeks time, my lord. 2 weeks time for amicable settlement.
Wife,
my lord, I am for the appellant. My brother-in-law.
Affidavit दियंतु नहले हम अर्जन करनु सेंतु oral mention रे जदि चाहुचंती जहा proposal दियंतु that should be on record,
my lord,
because this frustrates the proceeding. Why my lord has been asking, we are asking that because आपण अर्जन कर देले तापर से कोडे गला तापर so it piles up.
My lord, the positive result will come.
आपण दियंतु affidavit दियंतु तारे
wife
I am wife.
आपण husband पे आपनकर भी property दे दियंतु affidavit by next date like 10 days
your lordship has
amicable agree करचुंदी put to resumption of matrimonial relationship.
No, my lord, it is directed by your lordship that both counsels will sit along with their client and sort out a amount which will be paid by the husband to the son for his education. And in the meantime, I have intimated my client, he is ready to come here, but my friend client is working at Bangalore. So she won't get any leave to come.
So give a consent date so that both can come and affidavit will also come by that date.
What he is saying that she is coming on 27th of this month.
27th of this month.
We are proposing to sit on 30th.
27th
date दियंतु August first week
August first week any date your lordship
and work it out.
Any date.
31st रे आसु
my lord.
Yes.
31st रे आसु सी जदि 27 रे आसुची ताले both side तांकर affidavit दियंतु किबा joint affidavit आपण जदि settle करूचंती दियंतु by 28th or on the date at least
Lord, she is coming on 27th, so we are
27
proposing
ହେଲେ so
to
27
on
28
30th.
ଦିଟା ଦିନ ଗୋଟେ ମିଳିବ। So
We are proposing to sit on 30th Sunday.
38 ତାହେଲେ ଆମେ ସେକେଣ୍ଡ କୁ ଆଣିବା।
Yes.
କାହିଁକି ଶୁଣନ୍ତୁ ଏଇଠି ବି ମନେ ରଖନ୍ତୁ ସିଏ ଯଦି ବାଙ୍ଗାଲୋର ଆସୁଛି ସିଏ ଆସିନଥିବ ମାସେ ଛୁଟି ନେଇକିରି
7 days. What?
ସିଏ
my
7
plan.
ଦିନ ନେଇକିରି ଆସିବ ସେ ପଳେଇବ ଆମେ କେସ୍ ଟା ପୋଷ୍ଟିଂ ତା ଭିତରେ
Yes,
କରିବା ଦରକାର।
Yes.
ଦେଖ let us bring the matter on first.
Yes.
So first ହେଲେ 7 ଦିନ ଭିତରେ ରହୁଛି ଆମେ ପର୍ସନାଲ ଆପିୟରାନ୍ସ 2 ଜଣ ଯାକର ବି ଦଉଛୁ ସେଦିନ ଏବଂ ଲେଖ both sides seeks time on the premises that since the husband in appear herein will be available in the state from 27th onwards.
And is posted at Kolkata. He can come
Wife
any
who
day.
is working in an organization in Bangalore is to be available in the state on 27th. Husband it ଅଛି
Kolkata. Calcutta.
Calcutta.
He can come on Saturday.
Okay.
Any day.
The counsel for ଆପଣ ତ appear କରୁଛନ୍ତି respondent ପାଇଁ।
Husband.
husband ପାଇଁ।
Yes. He is appearing for that.
ଆଚ୍ଛା। Okay, this court and therefore an adjournment is sought for to facilitate both parties to sit together to find an amicable settlement between the parties. Okay, considering the request of both the counsels, this matter stand adjourned to 1st of August. At the same time, this court, while directing the matter to be listed on 1st of August and directing both parties to remain present in court in person, this court also direct the husband, the respondent herein, either to file a joint affidavit on mutual agreement of parties, or at least to file his property list and the consent for grant of appropriate compensation for the towards permanent alimony in the appropriate resolution of the matter. है ना? ठीक करते हो ठीक ठीक ଅଛି ଆଉ ଯାହା ରହିଲା ସେ ଯୋଉ ମ୍ୟାଟ୍ରିମୋନିଆଲ 20 ର ବି ଆର ସପ୍ତାହକୁ ନିଏ
item 12 ଟା କାଲି
ଆର ସପ୍ତାହ ରହିବେନି
ନାଇଁ ଅଛି
ରହିବେ ଶୁଣନ୍ତୁ ଆମେ କଣ କରୁ ଆମେ ତ ସିରିୟଲି ଯାଉଛୁ ଆଉ ଆମର ବି ଡିଭିଜନ ବିଭିନ୍ନ ବେଞ୍ଚ ଏ ଭିତରେ ଗୁଡେ ମିଟିଂ ବି ହଉଛି
small matter ଟେ ନାଇଁ 12 item 12 tomorrow ଆସୁ small matter ଟା
small big ଆମେ we don't know ଆପଣଙ୍କ ପାଇଁ
ତ ଅଛି ଆଉ କଣ ଆପଣଙ୍କର ଚେଷ୍ଟା କରାଯାଉଛି ସିରିୟଲି ଉପରକୁ ଯିବ ଯେମିତି
ଆପଣ ସାରି
ନେକ୍ସଟ
ଆମକୁ ଦବାକୁ ପଡିବ therefore small କହିଲେ କଣ କମ୍ପ୍ରମାଇଜ ହେଇଯାଇଛି କି
ନାଇଁ ସେ ହଜବେଣ୍ଡ appear କରୁନି କିନ୍ତୁ
ତାହେଲେ ଜଜମେଣ୍ଟ ଦବାକୁ ହବ
refuse to receive that is sufficient LCR
ତାହେଲେ ଜଜମେଣ୍ଟ ଦବାକୁ ହବ therefore wait ଅଛି ଆମ ହାତରେ କିଛି ଜଜମେଣ୍ଟ ଅପେକ୍ଷା ପେଣ୍ଡିଂ ଅଛି ଆମେ କ୍ଲିୟର ନ କଲେ ଆଉ ଜଜମେଣ୍ଟ ରିଜର୍ଭ କରିବୁନି
Item one.
Item one, Mr. Panda was supposed to do it, but I find from the brief. Fortunately, he has not been able to come. I find, Lord, I have received certain instructions, our office, that there has been complaints. So let this matter come day after tomorrow, so that he can explain.
ଆପଣଙ୍କ ଇନଫର୍ମେସନ କଣ କମ୍ପ୍ଲେନ ହେଇଯାଇଛି କି?
ଆସିଛି ମୋ ପାଖକୁ instruction
Only
ଆସିଛି।
ଯଦି ଆମେ କ୍ଲୋଜ କରିଦବା କାହିଁ ରଖିବା?
only letter communication has been done, so that apart nothing has been taken as per law.
ହଁ ହେଲା ତାହେଲେ ଡିସିସନ ହେଇଗଲା। ତେଣୁ ଆପଣଙ୍କର ଫର୍ଦର କୋଜ ଅଫ ଆକ୍ସନ କଣ ଅଛି ଆପଣ କରିବେ? ଆପଣଙ୍କର ରିପ୍ରେଜେଣ୍ଟେସନ ଡିସ୍ପୋଜାଲ ଡାଇରେକ୍ସନ ହେଇଥିଲା।
ଆଜ୍ଞା।
So
representation ଦେଲୁ। ଦେଲା ପରେ only
ହାଇକୋର୍ଟ ବି ଡାଇରେକ୍ସନ ଦେଲେ ରିପ୍ରେଜେଣ୍ଟେସନ ଡିସ୍ପୋଜାଲ କରିବା ପାଇଁ। So disposal, manner of disposal is immaterial. Manner of disposal we have never said.
Simply କେବଳ communication କରିକି secretary କୁ ଛାଡିଲେ ବାସ୍ ସେତିକି। ଆଉ ତା ବ୍ୟତୀତ ଆଉ କିଛି ନାହିଁ। No lawful decision has been taken so far. ଏବେ ବି ସାର୍ instructions ନଉଥିଲି କିଛି ହେଇନି ସାର୍।
Yes, has disposed. Accordingly, CDM PHO Jaspur by order number 710/22 has disposed the representation stating the above fact intimating the petitioner. So therefore it's over. All right. The petition was disposed of.
I may be supplied a copy my lord so that I can
with a direction
take instructions.
For disposal of the representation of the petitioner by CDMO. Representation by Dynasty 4 by the CDMO. Instruction memo submitted by Sri Ghosh, learned AGA, bringing to the notice of the court through para 3 that there has been already disposal of the representation by CDM and PHO Jaspur by the order number 7869 dated 7/10/22, copy of which is also enclosed herein. ଆପଣ ତାଙ୍କୁ ଗୋଟେ କପି ଦେଇ ଦିଅନ୍ତୁ so that he is getting the outcome. For there is already brought bringing in outcome on the representation of the petitioner following the direction of this court in WPC number so and so. This court find nothing suffice to be adjudicated. Content application thus disposed, however, observing in the event petitioner feels aggrieved by the communication, he has to find out the options available to the petitioner at this stage. ଗୋଟେ କପି ଦେଇଛି ସେଥିରେ ଲଗେଇଛନ୍ତି ସେମାନେ outcome ଟା. Instruction memo along with the outcome filed herein be kept on record.
But that has not been communicated to the
Item number two.
My lord, as per orders of the honorable court, two sets of, as per orders of the honorable court last date, I have already submitted the 2 extra copies and the LCR was called for.
LCR in fact call for ହେଇଛି receive କରିନୁ ଆମେ 7/7 ରେ ଆମେ ଚିଠି ଦେଇଛୁ 7th July ରେ we have intimated calling for the records.
ଆଣିଛନ୍ତି instruction
ଆସିନି 7/7 ରେ ଚିଠିଟା ଯାଇଛି.
Place this matter 10 days after on the request of the state council, who is directed to obtain instruction in the meantime, following direction of this court dated 5/7/23.
My lord, it's a covered matter. The covered matter,
Covered କଣ order କାହିଁ? Covered ହେଲେ ଆପଣ ଆଗରୁ ସବୁ କପି ଦେଇ ଦଉନାହାନ୍ତି କାହିଁକି? ଦେଇଦେଲେ ସିଏ ମାଇଣ୍ଡ ମେକଅପ୍ କରି ବସିଥାନ୍ତେ। ଦିଅନ୍ତୁ କଣ covered? ये जो बोधे चीफ जस्टिस का ऑर्डर है हम ऑर्डर बोधे आउथरे ये सोरे फाइल हो चीफ जस्टिस का ऑर्डर and then followed by me some orders
this court order
आताल छाड़न दिसता काटे दिया ये मोर ऑर्डर लाइन रे कर दो
ये संगति के annexes
ऐसा सब तो लिखो तो without expression of any opinion on the merit involved all right
my lord
आगुरु कॉपी दे दो था so that there will be no confusion and they don't find surprise again. Yes, 3.
Item number 3.
There is no filing of the impugned order. by Danish 5. Filing of certified copy of the impugned order by Danish 5 hearing. In this circumstance, the read petition is not entertainable, though dismissed, but however with liberty to the petitioner to bring fresh read petition after enclosing the certified copy of the impugned order. बहुत केस आसुची प्रतिदिन 10टी केस मु देखुची सर्टिफाइड कॉपी नहीं फाइल कर दूची अरे सर्टिफाइड कॉपी नहीं जति तमे जेरॉक्स पाइलो केमिति
से क्लाइंट आनी की जेरॉक्स कॉपी दे दउचंती सेथरे फाइल
कर देले अपेक्षा भी करू ना अरे बाबू नहीं गिरिया
Item 4.
I have already complied.
नहीं
I've already complied. I haven't submitted the certified copy of the impugned order.
ये फाइल
Yes, already filed.
के फाइल करले
फाइल को से এটা হচ্ছে 10
Danish 5 तो
Yeah, I
हाँ it is here नहीं तो it is ଆପଣ ଆଗରୁ ଯୋଉ ଆନେସର 5 ଦେଇଥିଲେ 4 ଦେଇଥିଲେ
ସେ ତାପରେ ମୁଁ ଫାଇଲ କରିଛି ରିସିପ୍ଟ ଅଛି ମୋ ପାଖରେ ରିସିପ୍ଟ
କୋ ଅର୍ଡର ଟା ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି କହିଲେ
ଆନେସର 5 ଟା ସର
27/5
ଆଜ୍ଞା 27/1 27/1
27/5 ହେଲେ ସାର୍ଟିଫାଇଡ୍ କପି ଅଛି
27/1 ସର ଲାଷ୍ଟ ଅର୍ଡର ଆନେସର 5
ଏଟା କଣ ଦିସ୍ ଇଜ ଇନ୍ ଆପିଲ
yes
appeal ରେ mutation order set aside कर देई कहले पटा देई दियो
आया सेटा सर
नहीं तो रिमांड
नहीं रिमांड कर दे सर सूट in my suit was filed by the petitioner and others that was that went in my favor that the right title interest is in my favor thereafter I went for mutation of the land that was rejected by the additional Tahsildar on the ground that since he against that order he filed a second appeal before this honorable court and after 11 years that Lakshmi remanded the matter that for that is second appeal is still pending but no stay is there that is the
no the appellate court finds that Tahsildar order was an expiry order that's why he has remitted the matter
but
back.
this is not no expiry order Lord
So that cannot be gone into now.
Which is expiry order Mr. Lakshman see that may I read the order Lord
Seda answer kete
good sir
this order dated 6/5/22
yes brother that is the
6/5/22 ta asantu answer 3
answer 3 Lord answer 3 Lord I made that is the order for that is the appeal Lord that the case is record is put up today and advocate for both parties are present and called file gone through the record it is seen that the said case has been instituted on the strength of orders passed by civil judge senior division commissioner in title suit number 29 but the case was dropped as the orders passed in title suit number so has been challenged by the RFA in 2017 which is pending in the honorable the Odisha High Court Cuttack had the land council
so that was earlier appeal order
yes that's
earlier appeal order it was remanded
is remanded that is still pending
hela pore
se kohusinde amu to mutation karibuni no stay is there and this sub collector has also
no, that's a different issue that's a different issue now but where is the order dated 26/5/22
yes Lord that is
it is annexure 4
yes, annexure 4 Lord that is additional this he allowed
against that he allowed this order probably expiry order
no experts are dijon
yes this is expiry order
blood could sir a order sir
26/5 is expiry order
20 no sir 25 experts may read the order blood made the
yes,
order
please
this case is put up today peruse the orders passed by sub collector Kamekner mutation appeal number 1328 arising out of mutation case number so and so sub collector Kamekner has passed an order
kai au poduchendi where has he had the parties से खाली पेरूस कर देले appellate court रो order टाको pass कर देले order where has he recorded the submission of both parties or even hearing both parties Mr. Patnaik forget leave it and it is remanded so therefore there is no final conclusion opportunity with you
only
to still have your case
only motto is of the authorities that since second appeal is pending mutation
that order no more stays that order is set aside matter is reopened now
yes the remanded
reopen hale kai apna asli and reopen on the plea that the earlier order was expired had the submission of Sri Patnaik and counsel for the petitioner and Sri Panda Petitioner herein impugned final order passed in mutation appeal 28 of 22 by Dhanesha 5. Taking this court to the order interfered in the order by Dhanesha 5, particularly the order dated 26/5/22 available at Dhanesha 4 of the brief. The Patnaik attempted to submit that order cannot be construed to be an ex parte order. It is in this circumstance, Sri Patnaik contended appellate sub-collector, the appellate authority has not applied due mind in deciding the appeal. Therefore, the interim impugned order must go. Sri Pandal and her counsel appearing for the state, AG appearing for the state, however, on rereading of the order at Dhanesha 4 submits, in fact, there has been no recording of submissions of parties, or at least hearing the parties involving such proceeding. In this circumstance, Sri Ponda attempted to justify the impugned order, Dhanesha 5, considering the rival contentions of the parties, perusal of order on the strength of submission of both counsels. This court find, in fact, there has been no recording of at least involvement of counsel for both sides or parties for both sides in the disposal of the proceeding by Dhanesha 4 by the order dated 26/5/22. In this circumstance, this court find the appellate authority in disposal of mutation appeal 28 of 22 is justified in allowing the appeal on the footing of ex parte order dated 26/5/22. No ground available for interfering in such order. This court further also observed for the open remand of the mutation proceeding, petitioner has ample opportunity to bring all such grounds raised herein in the further hearing of the mutation case 1182 of 15. Thus, there is no serious prejudice to the petitioner even. In this circumstance, and for the reason assigned herein, this court find no merit in the writ application, which ought to be dismissed and dismissed hereby. Yes.
Let me remind the matter.
Provided the mutation case number so and so is still pending adjudication, it may be open to the petitioner to participate and contest such proceeding.
Yes. Let me liberty to
Pardon?
Liberty to participate in the
हम कहले जे प्रोसीडिंग पेंडिंग थियो आपण तो याडे दौडुचंदी सियाडे कोन हलानी कोन जानचंदी की सियाडे सर जाई थाई पारे देखंतु दैट्स व्हाई आई हैव ऑब्जर्व्ड इफ द प्रोसीडिंग इज पेंडिंग इट विल बी ओपन टू यू टू पार्टिसिपेट आपण भूल द्वारा धरचंदी आपनकर काई भूल होउची
नहीं सर फर्स्ट बिल्डर से मोर इन माय फेवर सेकंड बिल से 10 पर 11
डिमांड हेची एक्सपर्टी ऑर्डर रहीची आपण क्लाइंट को एडवाइस कर दवा कथा ना मिस्टर पटनायक आउ कोन खाली हमें फाइल करबा इन ए वे टू अर्न मनी and how are we serving to the judiciary? Yes.
Item 5.
disposal of mutation.
Okay. Mutation case, 1963 of 22 prayer code directed to be given final outcome, a lawful outcome, at least within a period of 2.5 months, but however, providing opportunity to parties likely to be affected. Yes.
Oh, like
Item 6.
May I please, Your Lordship? The petitioner, the wasteland lease property, which was purchased by the petitioner in 81. Thereafter, there was a dispute internecine between the parties, where the state was also a party, and the matter culminated before this honorable court in second appeal. Your Lordship will find that judgment at page 28, and the relevant portion is at page 32.
Yes.
Page 32, where I talk about the court talks about my right.
आपण तो सबु दाग देई देले हमें कोड दाग दोबो
Sorry, very sorry, Manoj.
No,
You could not copy.
instruct
See,
your counsels to give a proper copy.
Absolutely. It should, a typed copy should have been
I
supplied.
find there has been a lot of scoring outs.
So, in fact, in this second appeal, the state supported the claim of the petitioner
So
that
there
he
is recording. Suit came to be filed. State supported the case of the
plaintiff that he has title over the property.
and therefore there is a judgment.
There is a judgment of this honorable court. Thereafter, in settlement proceeding, the ASO records it in the government khata. And thereafter, appeal has been filed. We do not know what is happening in that appeal, but that has become redundant in view of the division bench judgment of our own High Court.
So the private party must be there.
No private party. It's the state. The state's order is settlement proceeding orders have been
Then
challenged.
take notice. Take notice. Issue notice on the question of admission. This court observes the matter shall be decided in the next listing of the matter. For all the opposite parties required to be represented through state council. Let there be 5 copies of the brief be served on the learned AG. Yes, you take instruction, please.
My lord.
Matter be posted after 4 weeks for out a date. Please.
Your lordship, there is 2 other matters along the same line. Asini se number गुड़ा के tag कर दी था जो एक संगे tag कर दी था ना along with 19705 19710 of 2023.
These are all admitted.
No, not admitted as yet.
Fresh admission.
Fresh admission.
But in the meantime, you ensure service of copy on them.
सब गुड़ा चाट्टा को दे
देवे so that
चाट्टा को copy दे देती.
Along with a second matter टा भी कौन
same चाट्टा matter एक ऐसे फैली.
ये दीटा अच्छी आउ दीटा.
आउ दीटा.
Okay, this matter shall also be listed along with a 19705, 19710 and 19712 of 2023. In the meantime, counsel assisting the senior counsel Sri Mukherjee undertakes to serve extra copies in all these matters on the learned AG.
Item 7.
Gautam, senior counsel.
Item 7 made please your lordship. Someone BC your lordships. Pardon. This is but it has been filed because of the non-execution of the lease deed, your lordships. The
Non-execution of
has purchased the property. Again, BDA, your lordships. The first case is BDA.
Lordship, I am appearing on behalf of Mr. Dwandama.
We have disposal to answer 4 requests.
We have to take instruction, my lord. 7 days time may be granted.
Instruction neve. First time SC.
Yes, my lord.
First matter first time. First matter first time SC. All right, one extra copy be served on Sri Anand Mahapatra, who usually appears for the development company. Matter be listed 10 days after date in the fresh admission, indicating name of Sri Anand Mahapatra as the Council for Development Authority. Okay, this court observe pendency of the writ application may not stand on the way of the Development Authority in giving a lawful disposal to the representation by Dynasty 4 pending, claim to be pending with the Development Authority.
Lordship, the second sub-item is also same, but this is CDA, lordships. It has been wrongly tagged together.
Let the representation of annex by annexed
instruction
representation be considered within a period of 1.5 months.
Representation
Annexed 6
lordships. Representation way, that is a reply, your lordships. Your lordship will see annexure 5 veterans. After the task force report, it was claimed that the case of the petitioner.
Any judgment of mine is covering?
Yes, your lordship's judgment.
Because task force he had encroached on unnecessary issues.
Again.
So I have clarified in so many writ applications, so many issues. It doesn't come under the task force purview.
I'll supply the
I
copy of
can
the
direct
judgment.
disposal of financial sheets taking
Yes,
into account the judgment in so and so. So give
Yes,
it in sleep.
I am
Sleep.
I'll provide.
Prayer court had the submission of Ms. Professor Naidu along with Sri Dayanand Mahapatra for the opposite party. In the course of submission, this court find on the self-same issue, there has been tendency of a representation at the instance of petitioner. Guidance 6. It is a claim is also made by learned counsel that the claim of the petitioner is well supported by the judgment of this court in the process and for the getting an outcome by the competent authority. This court in the disposal of writ application Annexure 6 let the outcome become within a period of 6 weeks, but however, in the involvement of petitioner and also take into consideration the judgment cited here in above, copy of which being supplied to the development authority.
Deeply obliged.
Pleasure.
You are still engaged, Madam Naidu. You are still engaged in NLU.
Revenue?
Engaged in NLU.
No, your lordships, I did. I
No
stopped
more.
2 years back.
No more.
2 years back.
All right.
Item 8.
Lordship, this matter is relating to non-acceptance of rent by the OP number 3 Tahsildar, which is covered by your lordship order.
Yeah. Earlier it was being accepted.
Yes.
Earlier it was being
Yes, your lordship.
accepted. Where is the receipt? At least one receipt. Upon sell deed dele, record of right dele. Receipt kahin?
Sorry, your lordship. This is in name of the petitioner. Your lordship, kindly have a glance to Annexure 3. Your
Achhi,
lordship.
Annexure 3.
Yes, your lordship. The ROR.
Page.
The name of page 15, your lordship.
No, this is record of right.
ROR, your lordship.
ROR is already corrected in your name.
Yes, your lordship.
And thereafter also no. Okay. এটা তাহলে খাতা নম্বর ফম্বর চেঞ্জ হবো পেন্সিল রে করদেলেনি কাহিଁକି খাতা নম্বর প্লট নম্বর ସବୁ চেঞ্জ হবো ହେଲା ওকে এটি Annexure 2 টা ବି 3 হবো right without prejudice accept ROR is already there. Yes.
Item 9.
Pleasure.
May I please your lordship.
Yes, Mr. Behra, Arku.
Annexure 7, your
Order
lordship.
in mutation appeal is under challenge.
Yes, my lord.
What is the ground?
Ground is, my lord, your lordship can find Annexure 6 at
One
page
minute,
35.
mutation appeal order, where do you find?
That order is not that appeal memo when served upon me.
No, appeal memo is there.
Yes, my lord. That is served upon me by notice.
Okay, you want to take away the appeal.
Set aside the appeal.
Why? You can
Because, my
file
lord,
the-
Annexure 6, the mother.
No, that's right. You file your objection
Objection
to
to
take
the-
out the proceeding. Let him take a decision. Why High Court at this stage?
Only on the ground that, my lord, once the property has been sold with the consent of all the co-sharers.
Sorry.
And the civil suit is pending.
When an opportunity is available with the competent authority, why High Court step in?
Because, my lord, the ultimatum
It is
result
just
will come in
service
the
of
suit, my lord.
memorandum. You go
Sekhar,
and file
Sekhi
your
kahibe.
objection. I'll say all the grounds taken herein shall also be taken into consideration. That's all. Undisputedly, petitioner has approached in this writ petition at the stage of mere service of copy of the mutation appeal 107 of 23. Petitioner has so many grounds in taking out the appeal memorandum made in the writ petition. For the opinion of this court, once the petitioner spoke to appear and raise his objection in the appeal proceeding, High Court at this stage of the matter should not step into interfering in such actions. In the circumstance, even though High Court declined to entertain the writ petition at this moment, however, observes in the event the mutation appeal 107 of 23 is still pending, it will be open to the petitioner. You are already a party there.
I am party,
The
my lord.
respondent one therein. to raise all such objections raised herein for consideration of the appellate authority. This court hope and expect in the event of submission of objection of the respondent one therein, the appellate authority shall do well in giving a lawful disposal in the involvement of in consideration of the grounds raised by the respondent therein. Yes.
Item 10,
Yes.
May I please, Lordship? Lordship, in this case, the land has been muted in my name, but in
42 OSS is not appellable.
No, 42 against the 42A re achi revision. She has come up against the order of appeal, but in fact, she was successful in the mutation proceeding. As against that, a private party has gone up in appeal. Appeal was allowed and the matter has been remanded again to the mutation authority. That is page 13, you will also will find from the appellate court's order.
Right, I have seen that. But
The revision lies 42A.
So the earlier proceeding was taken out on the ground of limitation only.
Yeah.
And that was the ground in appeal.
no, Lordship. In appeal, ground is that the easement right, and without giving me any opportunity of hearing.
Or it is ex parte.
Yes, Lordship.
Then any private party there?
Yes, Lordship. Private party 4 and 5.
Actually,
And
4 and 5 will notice.
May I just suggest one thing, Lord? Since matter has been remanded to the original authority, that is mutation authority, where she was successful, now she will also avail the opportunity there.
No, but why an appeal will be disposed
No,
without
the notice out.
unnecessary.
Aye.
So this can also be thrashed out in appeal. The sole ground of challenge to the order at annexure 2 appears to be the impugned order annexure 2 has been passed without afford opportunity to the petitioners therein. Now, upon city
Respondent.
Respondent, private respondents therein, who are petitioners herein. Hello. Okay, this court is inclined to entertain, even in spite of opportunity available as an outcome in the appeal. However, keeping in with the serious allegation taken note herein above, this court is inclined to issue notice, notice accordingly. Matter be placed immediately after the appearance of the private opposite party.
The order is apparent also. Page 10 re, respondent remain absent on call. So it has been passed. Same scene ହେଇଯିବ.
Same ଜିନିଷ ଆସିଯିବ.
Oblige not.
Miscase ନାହିଁ, miscase ନାହିଁ.
Miscase file
କାଇଁ ଫାଇଲ କଲେନି? ବର୍ତ୍ତମାନ ତ ନୋଟିସ ଗଲା, ରିମାଣ୍ଡ ହେଇଯାଇଛି। ସେ ରିମାଣ୍ଡ ପ୍ରୋସିଡିଂ ଟାରେ ପ୍ରୋସିଡ କରିଯିବ ନା ନାହିଁ?
ଷ୍ଟେ ମାଗିଥାନ୍ତେ ନା।
ସିନିୟର କହିଲେନି ମିସକେସ୍ ଫାଇଲ କରିବା ପାଇଁ। ପଇସା ପ୍ରବଳ ଆସିବ, ଫାଇଲ କରିଦିଅ ଯାହା କହିଦେଲେ ଆଉ। ଯା ମୋର କିଛି ଦାୟିତ୍ୱ ନାହିଁ, ମୁଁ ଖାଲି ଆପଣଙ୍କୁ ଜଣେଇଦେଲି। କେମିତି କରିବି? ମିସକେସ୍ ଟା ନାହିଁ।
ଏଇଟା ଫାଇଲ କରନ୍ତୁ।
There is no miscase here. I was rather looking to a miscase. ମୋର ଅସୁବିଧା କଣ କି ମୁଁ ସବୁ without finding a miscase, but I find there is difficulty in absence of miscase to grant an order. So bring a miscase in orders.
ସେଠି ଯାଇକିରି ବି କହିବେ ନୋଟିସ ହେଇଛି ବୋଲି ରିଟ୍ ରେ as against the appellate order.
ମାଲପତ୍ର ପଡିଗଲା ନା, ସିଏ ଆଜ୍ଞା କିଛି ଶୁଣିବେନି ବ୍ରହ୍ମା ବିଷ୍ଣୁ।
ଏଇଟା ଫାଇଲ କରିଦିଅନ୍ତୁ।
Atleast file କର। Yes.
Item 11.
Both the matters are covered matters.
Your ROR is to be prepared on the basis of what?
K form.
K form ଦିଅନ୍ତୁ। Copy ଦିଅନ୍ତୁ। Covered order. Yes.
Item 12.
Yes, ଶୁଭୁନି କିଛି।
For day after tomorrow, my lord.
Day after tomorrow. ଆଉ list ହେଲା କାହିଁକି?
In the meantime, copy short.
Seeking correction of record of right. ପୁଣି day after tomorrow କାହିଁକି?
Copy ଟା ସର୍ଭ ହୋଇନି।
ଆପଣ ପାୱାର ନାହିଁ? ପଢିନାହାନ୍ତି ବ୍ରିଫ? ଗୋଟେ ରିଟ୍ ପିଟିସନ ଡାଇରେକ୍ସନ ଡିସ୍ପୋଜ ହେଇଛି। Oh, এটা Hare Krishna. Yeah, out a party.
Copy दे
All right. Next Tuesday करते.
copy को दे दो copy दे
Keeping in view the request of the learned counsel for the petitioner. But as a matter of last chance.
office रे
Yes.
Item 13.
Wait, please, your lordship, but I want VC.
Yes.
Well, but here this writ petition arises out of the orders passed in a proceeding under section 22 of the OLR Act for grant of permission. Your lordship will see my land particulars that I had provided before the competent authority.
Private parties are there.
My purchaser, proposed purchaser is made a party. But otherwise, grievances against the revenue authorities.
Where is the impugned order, certified copy?
That's a file.
Yes, it is there.
Mine. Page 44, annexure 9 is the order of the sub-collector. Page 44, if your lordship sees.
Yes.
44.
Yes. Order is at 45.
Yes, my lord. Order is at page 45.
Yes.
And the relevant portion is at page 46, my lord.
Yes.
Yes, my lord. If your lordship sees the first paragraph, he goes through the report of the inquiring officers deputed by the collector, my lord. But thereafter, in the third paragraph, is the finding. That your lordship will read from the report of the ADWO. From the report of the ADWO. Yes, my lord. It reveals
that.
I'm sorry, my lord.
Continue karantu.
Again. From the report of the ADWO Bhawanipatna Sadar, it reveals that after selling the proposed land measuring in area of acre 0.13 decimals under Moza Hatia Tangar, Bhairavpur district, Keonjhar, the land for an area of acre 10.54 decimals under Moza Damkarla Khunta of Emrampur Tahsil in the district of Kalahandi will be existing in the name of Ranjan Kumar Bad. The said report appears to be suspicious as the applicant has already obtained ROR for an area of so-and-so in favor of him, which reveals from the requisites submitted earlier by the
Section 22 of OLR Act is appealable.
yes preferred appeal and appeal confirm each
Appeal confirm is. Okay, then
annexure 11
then take appeal order you are also challenging.
Yes, my lord. The subsequent annexure.
Take notice.
Yes, my lord.
So notice on the question of admission. Notice accordingly.
it's revisable also. It is also revisable.
କାହିଁ ତା ଦେହରେ revision ପୁଣି କରୁଛନ୍ତି ସବୁ.
Item 14.
Revision petition pending for fresh admission.
Fresh admission.
Fresh admission.
Okay, all these matters,
Yes,
case
yes.
number खाली change हो.
All right.
Item 15.
Not registering the objection case, the Aston settlement also forward.
Mike रे कुहंतु.
Objection case is has not been registered by the Aston settlement officer.
Accept the register application.
Application annexure 2.
Okay, all right. Yeah. एवढा आपण कहीं କରୁଛନ୍ତି आपण जूनियर मानु कहीं दउ नांती आपण को जूनियर मानु करियो कहीं दउ नांती के
Item 16.
May I please, Your Lordship? Your Lordship, in this case, the petitioner has approached this honorable court.
Raise the mic.
The petitioner has approached this honorable court challenging the order dated 7th March 2022 and 7th July 2022 passed by the opposite party number 3 secretary cum member estate BDA for cancellation of the second allotment of house granted in favor of the deceased allottee. The petitioner is the son of the deceased allottee Shri Damodar Ananta Behra. The petitioner prays before this honorable court to set aside the second allotment passed by the OP number 3 at annexure 8 and 9 dated 7 March 2022 and 7 July 2022.
So what are you doing? These were all orders passed a year back.
Pardon,
What
your
were
lordship.
you doing so long?
Your lordship, actually, the petitioner, who is the son, along with the deceased mother, the allottee passed away in the year 2013. Thereafter, they ran.
That's the ground. I don't ask for ground. What were you doing? You have to know. Annexure 8 was passed on 7/3/22.
Yes, lordship.
Then Annexure 9 was passed on 7/7/22.
Yes, lordship.
And year, almost 1 year and 3-4 months in one order, and 1 year have passed. What were you doing?
Your lordship, the petitioner does not have any idea about the legal
All
process.
right. You are in possession of 2 properties?
2 properties, but the first property which was granted under the plotted development scheme 1991, the said plot is lying currently vacant, and the current petitioner is in the possession of the second.
Do you propose to surrender 1 property?
Yes, your lordship.
So find out my judgment. Find out, I have given a judgment wherever parties agreeing
Yes, your lordship.
to surrender in keeping the better plot.
Yes, your lordship.
So an affidavit is required to be filed before the authority.
Yes, your lordship.
And they will accept that.
Yes, your lordship.
So you serve copy,
Yes, your
Okay.
lordship. Your lordship, at annexure 9, page number 31, they had stated that to bring any relief order from the competent court. They are asking.
Pardon?
They are asking for the relief order from the competent court.
That's right, all right. So therefore you serve copy, I am taking this next week.
Yes, my lord.
You also support him, or provide him the copy. I have, in one case I have said, if party is agreeing,
Yes, my lord.
then he will surrender the unsuitable plot. He may retain the better plot.
Yes, your lord.
Yes,
Here
your
is a
lordship.
bona fide party who doesn't contest to hold on both the properties. So issue notice on the question of admission, fixing short return date. Since opposite parties so and so are to be represented by Danad Mahapatra, usually happens for them. 3 extra copies be served on Sri Danad Mahapatra. As undertaken by day after tomorrow.
So, your lordship.
By day after tomorrow.
Yes, your lordship.
Yes. See, next listing should indicate name of Sri Danad Mahapatra. But there is no application to protect your interest.
Your lordship, only oral communication was made.
Oral application is not entertainable here.
Yes, your lordship, we understand.
In the read petition prayer, have you made such prayer?
Yes, your lordship.
You are to be protected till disposal of the read petition. No, there is no prayer also. All right, in the meantime, there should not be any coercive action against the petitioner. Okay, in the course of submission, learned counsel appearing for the petitioner undertakes to expresses the desire of the petitioner herein in surrendering whose plot quota suffer.
We want to surrender the first plot which was granted.
Number, tell the number.
K8/824.
Okay, is ready and willing to surrender first allotment by plot number K8/824. Then he should notice very well. Yes. In the meantime, there should not be any coercive action.
Yes, your lordship.
Item 17.
Yes.
Lordship, the matter relating to the ostracism, Your Lordship, the Sarpanch and the ex-Sarpanch and the GRS has manipulated the signature of the petition and grabbed the money sanctioned in the Indira Awas, Lordship. Your Lordship, for that reason, the petitioner also brought it to the knowledge of the Supreme Court by filing the CRLMP.
That is your read court direction.
In the CRLMP, there was a direction to register the complaint. Thereafter, the complaint was registered by the local police.
Okay.
After that,
then you come to your prayer page 12.
That was the direction of the issued in another case. I have annexed the order itself.
Issue a read order directing OP to bring on record the compliance with the direction of this so and so.
That was direction was passed in the PILRC. I have annexed the order. That is annex of 4.
PIL, in a PIL.
On page 19.
All right, you take instruction. What happened? Extra copy be served on State Council. State Council is directed to bring instruction on the allegation of the petitioner. Place the matter 4 weeks after.
Problem.
Item 18.
May I proceed? Earlier occasion, this honorable court directed the opposite party number 2 to dispose of the grievance of the present petitioner, my lord. But instead of petitioner 2, petitioner 3 rejected my,
To dispose of the UAP case.
that is transfer of the house, my lord.
Okay, on that issue, you have a pending representation
Yes, my lord.
by Danesha.
That was last one, my lord, directed to dispose of my annexer under annexer 6, my lord. By the opposite party number 2, my lord.
6 page.
That representation is not filed this writ application, my lord.
Then what happened?
Opposite party number 3 dispose of my writ application, my lord.
That should be by OP3.
Yes, my lord.
Not by OP2.
Yes, my lord. Okay, that is page 9, my lord. Can you see? Page 9, annexer 1, my lord.
Okay, prayer court kar di for this court finding. Annexure 1 is pending with OP number 2. OP number 2. Eta the annexure 1 re kon seta?
He rejected by the opposite party number 3, my lord.
Reject kar dete.
Yes, my lord.
All right, then take notice, sir.
Housing board.
Housing board notice jibo.
Miscase, my lord.
Miscase re kon magichan?
Not to transfer the house, my lord.
Achi, you are still in
Yes,
possession?
Yes, ma'am.
Okay, miscase re kore notice. One say, notice as above. In the pendency of the writ application, there should not be a third party right created over house number LIG and on a status quo in respect of house number LIG 310, calling of Bihar change be maintained by all the parties involved. Okay, rest of the cases after recess suniva.
Item number 20 is your lordship's covered matter. Item number 20 is your lordship's covered.
Item
20.
Kona la?
Your lordship's covered matter. Correct.
Covered matter.
Yes.
Dijin copy dijin. Kona covered dekhi?
Narottama Ratha case man.
Item.
20. Copy tanku diyantu state ko.
No. Next question.
हाँ ये जो डिवीजन बेंच और
Yes,
all right 20 टा 20 टा साथ दो ना Annexure 5.
OP3 minor.
कौन करचंती रास्ता को ऊपर को उठेई दउछंती
माइनर annexure 4 माइनर 3-5 फुट पूरा घर पूरा आधा कवर कर दी माइनर पेज 15 and 16
ताले से घरु जीवा से बाट बंद होई
बाट बंद पूरा
Petition has the following claim of relief. It is the action to be taken by CMC.
Right.
Mr. Mishra, you are not there. CMC is to take steps.
Lordship.
No, prayer court kar do, but if on self-submission it appears Petitioner has a pending representation before the Cuttack Municipal Corporation, Cuttack. Considering the submission and the pleading and the request through the annexure 5, it appears there is unusual raising of the road, creating lot of hindrance to the houses existing in the area involved. Okay. Court, while taking serious note of such objections, hope and expect while considering the representation of the petitioner at annexure 5, the OP number,
Three,
ye
ma'am.
wo OP karibe.
2 my lord, Commissioner.
2. Undertake an inquiry exercise and do the needful manner without causing hindrance to the locals in the area involved therein.
Till then status quo, my lord.
Entire,
Till then status quo. Otherwise they
in
will
the event construction position kono.
ଆରମ୍ଭ କରୁଛନ୍ତି just.
So 7 days with the
My lord, my lord. See, commission.
Let a copy of the writ petition along with the order of this court be served on the OP number 5, OP number
2. 2 my lord.
2 and 3.
My lord, 2 and 3.
2 and 3.
My lord.
Hello.
Only commissioner, CMC commissioner.
The 2 ta commissioner pra. 2, 3 को भी 4 को भी दो.
My lord.
Project manager जायका भी involve हो. Planning officer भी कटक रो development रो हो. 5.
My lord.
All 3 will have joint inspection and inquiry within 2 days. Inquiry shall be conducted within 7 days. And the representation of the petitioner shall be given outcome within 15 days.
Till then status quo, my lord. Till then status quo.
Status quo forum.
My lord, otherwise they will construct the.
It is observed in the event there is unnecessary raising. It may be open to the development authority as well as the CMC to put an obstruction in the further construction of the matter. Yes.
Item 21.
Praise for Lord. Petitioner is challenging the order passed by the additional sub-collector by the annexure 13. In spite of this honorable court order, several orders, the similar order they have.
Oh, you have an order already in your favor.
Yes, my lord. By the annexure.
In a proceeding, annexure 13. Annexure
Yes, ma'am.
13.
13, my lord.
And now record of right needs to be changed on the basis of such order.
My lord.
So, what is the direction? Let us see in annexure 13.
Annexure 13 is the order of the additional sub-collector.
So, where is
Rejected
the direction for change in the
by the annexure 12, 11, my lord. Page
11? Page ko on.
Page 44, my lord.
44 is the High Court direction.
My lord. They have rejected my prayer to correct the ROR on the ground
So
of.
you are directed by this order of the court, you are directed to appear before the appellate.
Yes, my lord. I have appeared, my lord.
So then thereafter?
Thereafter, they have again rejected my prayer by the annexure 13, my lord.
By the annexure?
13.
13.
My lord. Page.
Okay, then take notice. Let us see. Private party there?
No, my lord.
Okay, take issue notice on the question of admission.
ROR finally published since 2014.
Mike.
ROR published since 2014. Lacks of jurisdiction.
No, if it is a rejection order, we have to consider it. Undisputedly, there is no appeal lies here. So you take notice, bring your counter.
Yes.
Yes, all right.
In spite of this honorable court order, they have remanded the matter, disposed of the miscase, and remanded the matter to the Tahsildar to comply the order of the honorable High
We'll examine.
My lord.
Yes, next.
Notice, sir.
Notice, Kali. notice alla.
Government.
Definitely, only state parties, na?
Only.
So therefore you will be serving adequate number of copies.
My
You see the order, thereafter serve copies.
My Public.
Yes.
Item 22.
Item 22, my lords, is a kindly be glance to annexure 4. My lords, annexure 4, the mutation was allowed on 25, annexure 4 page 35, my lords.
Yes.
My lords, kindly be glance to date order dated 20th May 2023.
Yes.
Mutation allowed.
No, pardon, sir. Case is taken
This
up
case
today.
is taken up today after receipt of the case record from record keeper, verified all the documents and RORs and found correct. At this in form number 3 case, no notice is required, hence mutation is hereby allowed. Send the case record to the record
So
keeper.
direction kar dele.
Just that order dekhuntu puni 21 tarikh din. Order record.
Seta kama form number 3 re jai natila.
Kon ami kichi jani parnu, am to notice nahi
No,
patta nahi
is
kichi.
it based on a cell deed?
Form
number 3, what is form number 3?
What they mean by form number?
Form number 3 is possibly the sub-register used to send a form.
Send a
form to Tahsildar for automatic
registration
of the new vendor, the purchaser.
Yes.
Rather.
Yes.
So is it not involving form number 3?
No, it is not. It is involving form number 3. May I submit my
But he said
I think it will not. If that would be so, I think that will not. The form number, the requirement of form number 3 is not necessary at all, because here.
So your submission, even apart from form number 3, you had a case.
Yes, but fact is, another repetition challenging.
So drop him the kardale. Suppose form number 3 is not supporting him. There is no form number 3, assume. Then otherwise also a decision has to be taken, proceeding to drop.
But that order dated 25/2023, that becomes a voidable order because he has referred to form number 3 and passed that order. So that is why perhaps he has realized his mistake and he has recalled it.
Then what should be the outcome? Should that order will be recalled or the entire proceeding will be dropped?
That order should only be recalled.
Order is to be recalled.
Submit mailers. Another WPC number 10241 of 2021 concerning the self-same property 10241 of 2021. That is pending. This matter may be tagged up with this so that both can be heard, because these are all involving the self-same property.
No, he pare, but aku kain tadhar tag korchu.
Sir, but revision say particular property da etre revision ra achi pending.
Tale eta asu jo gote dino.
Ha e dita jaga misikri asu.
Etar extra copy de diyantu. Mr. Mishra, you just obtain the file and find out whether form number 3 is there or not.
My lord.
And also take instruction what is this form number 3. What I understand, probably this form is sent by the registering authority to avoid any mutation proceeding. Now that's the procedure. One need not go for mutation. But here somebody is going for a mutation on the basis of a registered cell deed. So as an outcome, the mutation could have been allowed or rejected. Drop kar dele ko eta jodi somo
order ta ko be recall kar dele without giving up.
Are you sure you have instituted a mutation proceeding?
That is the man's kind of a glance to that order. That
received an application on
detail,
34.
Application detail.
Yes, it is at your instance.
Yes.
Therefore, a lawful order should have been given.
At least if you
recall calling it after 7 days time. You in the meantime take instruction. If that be so, we may recall this order and send the matter back.
And that to matters maybe tagged up with WPC in a self-same property. Another revision order is there challenged. The pursuant to that revision order, I played.
No, I find strange. Why are you tagging this? Let this order be. Let this order go.
There, the revision was allowed in my favor. They have come before the Hon'Ble order, there is no stay.
Mr. Mahapatra, you know well, it neither creates nor extinguishes right. Therefore, it is mere preparation of record of right. So, ultimately, it will be avoided by the result in
that. Obviously.
Problem will be 21 case I can't finish.
No, there is no necessity, my lords. That exactly what our my lord says. That would be the order in respect of both the cases.
Both the cases?
My lords. Because there, my lords, if they have any grievance, they have to come.
This matter 7 days after 8th day, working day. Along with 1024121, in the meantime, State Council is directed to take instruction as to the if the mutation case 580 of 23 contained form number 3, And in the event there is application under Rule 34 of OSS, Rules 1962 read with para 17 of mutation manual, if it is proper to drop the proceeding altogether without giving a lawful reason.
An opportunity of hearing also.
Yes, next.
Item 23.
May it please.
Yes, Mr. Kora. Mr. Kora, ଆପଣ କଣ ଏସବୁ କେସ୍ ଆସି କରୁଛନ୍ତି? ତହସିଲଦାର କଟକ for correction of record of right. ଆପଣଙ୍କ application pending ଅଛି ନା କଣ? It is on the basis of 37 order. It is on the basis of 37 order.
37 order.
Okay, I had this submission
A reference was made.
for the petitioner. Petition involved following prayer. Foundation in requesting for correction of record of right appears to be through the outcome in a section 37(2) of the OCS PFL proceeding by revision petition 2601 of 2006. This court in disposal of writ application observed as there involved an automatic action of the competent authority in bringing a corrected record of right, this could direct the Tahsildar OP number so and so to find out if there is no change in the 37(2) proceeding order involved herein, and in the event there is no change, the order is maintained as of now, there may not be any difficulty in bringing a corrected record of right. Interaction should be completed within 2.5 months of the order. ତଳେ କହୁଛନ୍ତି ମାଇକ ରେ କୁହନ୍ତୁ, ଆମେ ଆଜିକାଲି ସିଷ୍ଟମ ଅଲଗା ହେଇଗଲାଣି।
Annexure 1, the mutation application is pending. After the order was
ଆଉ
passed,
କଣ ଦରକାର mutation କାହିଁ ଆପଣ apply କରିବେ?
এটা ପୁରା
Okay, by giving disposal to mutation application pending hearing by annexure 1. এটা automatic 37 ରେ ଯଦି order ହେଇଗଲା, ଦାବି ମଞ୍ଜୁର ହେଲା, ଅମୁକ ଅନୁଯାୟୀ ପଟ୍ଟା ତିଆରି ହବ, ତାହେଲେ ସେ order ଟା ଖାଲି ସିଏ ବି ପକ୍ଷ ଥାନ୍ତି ନା ସେଠି, ସେ କଣ ତହସିଲଦାର ନିଜେ ପକ୍ଷ ଥାନ୍ତି, ତେଣୁ they have to work it out. ଠିକ ଅଛି, nonetheless you have gone for a mutation proceeding. So I am giving direction while also giving a lawful disposal to mutation proceeding.
within a deadline, my lord, within a stipulated date, the Lord Tahsildar.
2.5 ମାସ କହିଛି, ଆଉ ଅଧିକା ସମୟ ଦବା? ମୁଁ already 2.5 ମାସ କହିସାରିଛି।
Item 24.
May please tell us. Here the matter relates to settlement of government land and the
Which order? Annexure 4.
No, my lord, no order has been passed. Only I permit your lordship to approach in the appropriate format before the OP3 lordship. On
Under
that
the
of the
provision of
OGLS Act lordship.
OGLS ମୋଠୁ କେମିତି permission ନେବେ?
Relying upon
ଖାଲି
the
କହିଦେବି before appropriate authority ବୋଲି କହିଦେବି।
yes, sir, lordship. On that only observation the missing upon the long possession he has filed.
For the petitioner seeks withdrawal of the writ application in order to avail other opportunities available, remedies available to him. In the circumstance of the case, all are permitted to be withdrawn, however, with liberty.
Item 25.
25, may I please your lordship, my lord. Here, my lord, I am challenging the demarcation order passed by the Tahsildar Chandbali by the Annexure 4, page 19. Running page, my lord, kindly see 21.
Okay, this is a request under OGLS again. Come to page 14. Settlement of land under OGLS.
No, my.
Settlement of land under OGLS or not?
No, my.
Oh, dita file पड़ेगा कि? अच्छा. Okay, sorry.
My lord, Annexure 4, page 19, 19. running case 21, my lord, ordering person, my lord.
Yes, yes, demarcation case.
My lord, petitioner Gitanjali Sahu applied for demarcation of land Mauza, Panchapada, by consultation khata number 419473, but on verification of the record, it is found that there is no such.
Supuni,
khata.
supuni, कौन कहते?
But on verification of the records, it is found there is no such khata is existing as on record, my lord.
Where are you
But-
reading? Page 21.
My lord, page 21.
Read that portion.
The petitioner Gitanjali Sahu applied for demarcation for land of Mauza Panchapada by consultation khata number 419/473, but on verification of the records, it is found there is no such khata is existing as on record, my lord.
And also to impede the boundary tenants.
My lord, I have also implemented all the boundary tenant, my lord. All the boundary tenant, my lord, and notice was issued. One of the boundary tenant filed objection stating that one.
So all
Santilata-
boundary tenants are here opposite parties.
My lord.
Okay, take notice.
My. Oh, bless.
But demarcation re pota there is no such land existing ବୋଲି ସେ କହୁଛନ୍ତି.
My lord, but
ଯଦି ନଥିବ ସେ କଣ କରିବେ?
no, my lord, when I have filed the certified copy of the mutation ROR on the basis of mutation case, my lord, but he intentionally rejected my
Mr. Nayak, there is a great difference. You might have obtained a mutation order,
my lord.
provided the land is available.
My lord, they have intentionally
So
rejected.
something is on paper that cannot create a land.
No, my lord, my humble
Find
submission.
out, file appropriate
Lordship.
affidavit.
In fact, that is the finding he has given at the
That's the
bottom of the,
finding.
he has given that finding.
And my lord,
Consolidation map and ROR are not matching. Your lordship.
Matching. So
My
therefore, you may be going for a fight in civil forum.
civil forum, my lord, my humble
So
submission.
କାହିଁ ଏଠି fight କରୁଛନ୍ତି
No,
ଅଯଥା
my lord.
time loss ହବ.
No, my lord, my humble submission before lordships, my lord. Annexure
ଆଜି ଶୁଣିବାନି ରଖନ୍ତୁ କି ତାଙ୍କୁ ବି knowledgeable କରନ୍ତୁନି.
my,
Keep your weapons stacked.
my,
Weapons stacked. ହେଲା ହଁ.
oh, bless.
Well, here, my lord, I'm filing the show cause.
Item
Here-
26.
Item 26, I'm filing the show cause, my lord. Here we have stated the reasons why the order as yet, till date, my lord, it has not been implemented. So indicating our difficulties
What is the difficulty? First, let us know what was the direction.
direction is, my lord, it's simple direction to conclude the revenue miscase number so and so
Okay.
within a stipulated time, lord.
Okay, then
Now-
Mr. Ghosh, I am unable to appreciate the state stand. You may have genuine difficulties.
ନା ଆମେ ପୁରା ଫାଇଲ କରୁଛୁ ଆଜି ଆଇଓ ଗୋଟେ for modification seeking modification. Retre.
So then let this come along with that.
ଆଜ୍ଞା
I registered it.
ନାଇଁ ଏବେ ଯାଇଛନ୍ତି ରେଜିଷ୍ଟର କରିବା ପାଇଁ ଆଜି ଫାଇଲ କରୁଛୁ ଶୋ କଜ ଆଜି ବି ଆଇଏଟା ଫାଇଲ କରୁଛୁ
Right.
ସେ ପାରା
Okay.
ଆମେ ନେଇଛୁ actually କଣ ଡିଫିକଲ୍ଟିଟା ହେଇଛି
While filing a detailed show cause, bringing in the difficulties and constraints faced by the competent authority in giving an outcome pursuant to the direction of this court in the writ petition number 21074 of 22. It is also brought to the notice of the court by Sri Ghosh, appearing for the contemner, that in the meantime, the contesting opposite party have also brought a interim application for modification or clarification of the order involved therein. Please this matter along with IA register ହେଇଛି
ନା ଆଇଏଟା ରେଜିଷ୍ଟର ହେଇନି along with writ petition.
IA if any in WPC 21074 of 22. On Monday ଆଣିବା
ଆଜ୍ଞା
difficulty ସେ ଜଣେଇ ସାରିଲେଣି
ସେ ଦେଖି ଦିଅନ୍ତୁ
ଆଉ କାହିଁ contempt ଟାକୁ press କରୁଛନ୍ତି
Difficult second, after filing of the second contempt, they press a difficult.
ହେଲା
Till
difficulty
that they are not
ଥାଇପାରେ ଶୁଣନ୍ତୁ
filing.
ସରକାରଙ୍କର କଣ ଆଉ ସରକାର ବି ସେ ମାଇନର ଭଳିଆ to be guided by lawyers. ତେଣୁ lawyer କେତେବେଳେ proper advice କଲେ ନ କଲେ ତା ବୋଲି କଣ contempt ହବ ଗୋଟେ legal proceeding ଟେ complete ହଉନି contempt ହବ
ଆମେ କେମିତି ଜାଣିବୁ ସାର୍ କଣ କଲେ ନ କଲେ ଆମେ
ସେଇଥିପାଇଁ direction ଦବାଟା ଆମର ଭୁଲ ହେଇଯାଉଛି ଆମେ ହୁଏତ କହିବୁ will take steps for expeditious disposal କହି ଛାଡି ଦଉ
as per my client, more than 10 to 15 times he went to the Tahsil office. But they are not.
ता मकदमा अछि सी जीवन सी काई सब दिन जाउची
नहीं से कहछि कोन ऑर्डर कले दियंतु आगे कोन ऑर्डर करबे ना हम हाई कोर्ट को पठै दी
ओके ओके देखिबा ठीक अछि अल्टीमेटली देयर इट विल बी एक्सटेंडेड
For orders item 27.
एटा तारी संगे कंटेंट संगे
27, I filed my written notes, Your Lordship. Also serving a copy to my learned senior.
I am also.
Mr. Bag, you have filed a written note of submission.
Just now, no, that is a dead chart. Now I am filing the written note of submission.
Before Mr. Mishra starts, what are your viewpoint on law?
My lord, my first 3 points, my lord.
You have raised?
My first point is res judicata.
Just 1 minute. ये मोर आरो डेट रो कागज उडा को रहउनी काई भी नहीं तो लागिनी नहीं रखलोनी Yes, Mr. Bag.
My first point is
first
res
point.
judicata. Vide annexure 2 at page 26.
Res judicata being?
My lord, vide annexure.
Exercise undertaken right from original proceeding till revision.
Yes. No, my lord. My submission is vide annexure 2, that was a revision under section 32.
So that must be emanated from an appeal and then original.
Yes, yes, my
so
lord.
kain apo kanota ko bulei kain dekhauchandi
seta deini to
so therefore there is first round of litigation.
Yes.
Ended in a revision. Okay.
And 20 to 23 are.
Just go slow. Up to revision stage.
Yes, annexure 2, my lord. Page 20.
Right, yes. All
Then after disposal of the revision petition by order 19390, the opposite party therein, that is Suresh Chandra Khattai, sold the land to the present petition by annexure 3.
That is the fact you have already told.
Then he filed
Then,
the mute.
again that has been sold.
My lord.
There is preparation of record of right.
My lord, yes, yes. Then my lord.
Time, how many years have lapsed?
Now, in 2012, from 1990, 20 to 23 years, 2002, it is after 12 years.
2002, the further revision comes.
Yes, 2012, my lord, revision came.
Okay.
Yes.
That has been decided by the annexure
9 and consequence order is 9-10. Madam.
No, file the time. Just 1 minute. Upon file 18057.
Again.
Yes, I got it. Both master, I got it. Please take me to annexure 9.
Yes, my lord.
Page.
Page 59.
And this is a proceeding initiated in 2012.
My lord. And petition was taken up for first hearing and disposal 13/5/2013. My lord, short order, I may permit you to place that, my lord.
Yes.
This case is taken up today on priority basis. Land standing counsel for the state on behalf of the petitioner is present. Heard him. This revision petition has been filed by the collector Puri under section 32 of the OSS Act 1958 against the appellate authorities dismissal order of settlement officer Katak Puri, major settlement in appeal case number 251 of 2000, passed commonly in appeal case number days pertaining to the suitland. In Sabik record, the suitland was recorded in government khata.
This major settlement is appeal 251 of 2000 when it got disposed.
That is disposed of on
From your date chart, you must have.
yes, that it is there, my lord.
35 2000, your lordship. 35 2000.
35,2000.
Page 47 of the writ petition.
35/2000 annexure 4.
Page 47.
Yes.
Annexure 4. All right, yes, proceed.
It has been stated in the revision petition that the records pertaining to the suitland has been erroneously recorded in favor of the present opposite party during the initial stage of settlement operation, basing upon Jamabandi, which had been manipulatively and fraudulently opened in the tenancy ledger, but the settlement officer, by overlooking the said fact, has dismissed the aforesaid appeal on wrong presumption to be beyond their jurisdiction and civil court to decide title. All these things are wrong, my lord. The impugned order therefore appears to have been arbitrarily passed by the appellate authority, which is violating the principle of natural justice. Fraud being the main allegation, the appellate authority ought to have examined the claim of the appellant properly before dismissing the appeal.
He remits the matter. It is in these premises he remits the matter.
No, my lord. My submission is, my lord, the
No, has he not remitted?
no remit. He set aside it. Then he
said and remitted.
Yes.
Remit he knew.
No, my lord. My submission is that he has nothing to do.
That may be your argument. What
Yes.
is the reality?
Yes.
Reality is.
Now, why am I placing this, my lord?
The appeal order and remanded the proceedings. No,
my lord. My submission. Why I am saying
that's next is your argument.
Yes.
Remand tak bhi manna kar do.
No, remand wali lekhi jayega.
So set aside is remand.
Now, my submission.
Now you come to your argument.
No, my lord. My submission is by this annexure 9. Fact remains by the annexure 5 and 6. Revision was filed and limitation application was filed 12 years after. In this impugned order, limitation has not been condoned. Unless the limitation is condoned, the authority.
So that is your further ground.
Yes.
That is your further ground.
The authority does not get jurisdiction to pass the final order. So the final order being without jurisdiction is a nullity. That is my second round of argument. Then third is that when the fraud, manipulation, forgery, etc. has been adjudicated and decided by the annexure 2.
He did and adjudicated earlier.
Yeah, and
so such question is no more available to be considered.
Yes, and that is an future process of.
So that is your third ground.
Yes. My fourth ground is.
Just ticket.
My lord. My lord, yes.
So fraud, etc., having been already pleaded and adjudicated.
Yes. On their application, not on my application.
In the appeal.
In revision, appeal as well as in revision.
Earlier appeal and revision.
Again. And I have annexed the revision order.
Drive me to that area. That this was already a contention in the appeal and revision.
In my writ petition.
Appeal.
Yes.
Revision to appeal to annexure is dekhandu. You are making a submission, you substantiate it.
Yes, my lord, yes. Paragraph 12, my lord.
Paragraph 12,
page 9 of my writ petition.
Writ petition?
Yes.
Document uda nahi.
Document annexure 2, my lord.
Document ko niyo to सीधा देखिएगा.
Annexure 2.
Annexure 2,
page 26.
Page 26. 26 is the
writ petition, yes.
Yes. Court, तांको case code लिखा है देखेले.
My lord. Your lordship may kindly turn to next page 27, paragraph 27.
Yes.
Towards the last line, my lord. The Hatpota has been submitted as annexure 1. The opposite part number 2 sold this entire area by registered cell deed number such and such to present opposite part number 3. The registered cell deed has been submitted exhibit 2. An ekpadya also submitted by Dhaneshwar Rautra in favor of the opposite part note 2. This has been recorded to have been verified by the additional settlement officer. Then your lordship may kindly turn to next page. Page 28, my lord. Second line from the top. On the basis of the Jamabandi filed by the ex-intermediary, the tenant's ledger was prepared. There is thus little contradiction in the plaint, which at paragraph 3 mentioned that the ex-intermediary did not submit the Jamabandi after vesting, whereas in paragraph 4 of the plaint, it has been acknowledged that the tenant's ledger was prepared for this village Khalokota on the basis of Jamabandi furnished by the ex-intermediary. However, while preparing the tenant's ledger, the name of the opposite party was manipulated to be included in the tenant's ledger for an area of AC 21.76 decimal. The petitioner's view that is that even in the Jamabandi, the village which has been filed in another application number such and such on similar matter, there has been erasure in the ink had been washed away on the quantum of land. Actually, the quantum of land should be much less than AC 2.76 decimal and not AC 21.76. The petitioner case is that on the basis of such wrong recording made in the tenant's ledger in collusion with the
So therefore, earlier this fraud and
manipulation was taken into
always
consideration.
raised
Yes, my lord.
and considered.
Again.
Okay, then
Your lordship may kindly turn to page 29, paragraph 5.
Page
29.
Yes. 29, it is there.
Same, my lord, yes.
Threadbare inquiry.
Yes,
and
yes, yes.
The authority said, yes, it is correct.
Yes. Tenancy ledger is genuine, ekpadya is genuine, everything. And the miscase initiated by the
That's
Tahsildar.
para 5.
Yes, my lord.
Yes.
Then para 6, my lord, he formulated the questions to be answered. Whether the
Therefore, first question is on fraud.
My lord.
Okay, then what is your other ground?
My lord, after the your lordship may when your lordship is seeing the annexures, your lordship may see. Annexure 3 is my cell deed. And then your lordship may skip to annexure 4. After I purchase, in the form of mutation, I filed an appeal under section 22(2). That has been allowed. And ROR has been prepared by annexure 5 in my name.
That is there.
So, my lord, here this has been challenged under annexure 4. And the order is annexure 9. That means my mutation is challenged, not the order passed in revision.
So therefore, in the mutation proceeding also, these questions cannot be gone into.
My lord, because state was not a party, it was between myself and my vendor.
So this impugned proceeding,
yes,
is arising out of a mutation proceeding.
Yes, my lord, yes.
So
but they are
being the mutation authority, can he go to
my submission is
division
not.
in mutation proceeding?
No, my lord.
Maybe under OSS read with mutation manual, whether revisional authority can go to this extent.
My submission will not.
More judgment kind. I've already given a judgment.
My lord, I have read that, but I could not get it. My lord, sorry. Only by with the march.
Held to what extent the mutation authority can go.
My lord, yes.
Any dispute, parties are to be relegated back to civil proceeding, provided there is
Because I
no
am
earlier
not-
proceeding.
Because I was not in Patak, my lord, today morning I reached.
I had a
That's why, my
secondary
lord.
hearing.
But
Okay.
then, my lord, my submission is, in this appeal, my lord, they preferred revision, my lord, they can. 12 years or whatever it may be. But in the revision against this appellate order, they cannot challenge the order of forgery, fraud, manipulation, which has been concluded by the annexure 2 in 1990. And furthermore, assuming, my lord, while annulling this order and annexure 4, only my name will be deleted and my vendor's name will come in.
Why are you arguing that?
My lord,
Why are
sorry.
you arguing that? You argue on your right.
So my
benefit of argue kariba.
my submission is now
That is the worst submission. That's
My lord. Now my
in worst case you say.
My lord, yes.
Then why are you surrendering all these points? So why are you going to that extent?
Now my
Please.
submission is the initiation of
Now
the
bring your law, bring your distance.
initiation of the present revision and passing of the order is an abuse of process of law.
Abuse of process.
And on that line, I will cite a decision of the Honorable Apex Court.
Limitation upare decision आनिचंती की?
Limitation upare आनी नहीं आगे.
नहीं, बढ़िया क्वेश्चन. ठीक है, चला present proceeding is arising out of mutation. All right, yes. Now what is the?
Your Lordship, I submit.
Mr. Misra, you take your seat. Let me complete.
Flag B, Your Lordship, may kindly see first. Flag B. That is AR 2003 Supreme Court 718. It is both on res judicata as well as on abuse of process of law. Now, before taking a lordship to the points decided, law decided, my lord, I will tell the facts, my lord. Here, a person was granted some land as a displaced person. He expired. Then state proceeding was initiated. During that course, one lady, woman, claiming to be the daughter of that person, displaced person, filed an application. That was allowed. And against that, another person, claiming to be a tenant under that displaced person, contested the same. That was rejected. Filed appeal. That was rejected. Then carried revision. That was.
So the earlier order not being allowed, res judicata applied.
Yes. Yes, my lord. For that, your lordship may kindly see paragraph 11, my lord. Page 721. That is a quoted order. We find that
Mr. Bag, paragraph 11 is some taking down of some decision.
Yes. Na tapre court
So that is not their view.
Na court heavy heiche again.
That is
Tapre your lordship may kindly see paragraph 24
that
last.
decision might be helping there, therefore they have taken down a decision.
Yes, yes, yes.
So that may not be your.
Then 723, just above paragraph 25.
Just 1 minute. 2003 Supreme Court, page eta kete?
Page 718.
718.
Your lordship may kindly see paragraph.
Eta SCC re nahi?
Paile ni aga.
Dekhi nahanti?
Na.
Pila mane kon kuruchundi ajikali apanଙ୍କର?
Paragraph.
Kahi kouchi na in the event the order this way or that way is challenged. Supreme Court normally look to the SCC version.
Paragraph 24 towards last, my lord.
Amuku Supreme Court gali kariba na. Never follow AIR.
Again, 723 page, left hand side.
Para
24 last. 723 ru padhibe again. 7 line top ru left side re.
Yes.
Once it is held that the revenue authorities had the requisite jurisdiction to determine the said question, subject of course adjudication of the legality or validity thereof.
24 podchunta.
Again, 24 last, just above 25. Once it is held that the revenue authorities had the requisite jurisdiction to determine the said question, subject of course to adjudication of the legality or validity thereof in an appropriate civil suit, the issue which could or ought to have been raised in the said proceeding but not raised would be barred by principle of constructive res judicata, particularly when the other things are there, my lord. Then your lords may kindly turn to abuse of process of law, paragraph 31.
Yes.
In the aforementioned situation, in our opinion, the appellant must be held to have taken recourse to abuse of process of court, underlying the principle that the litigation should be allowed to attain finality in public interest, although the conceit of issue of estoppel or estoppel by records are distinct and separate.
All right. Next
My lord.
question.
The next decision is our own High Court decision, flag A, AR 1985 Orissa 7-4.
Yes.
That is paragraph 6 and 8. That is regarding res judicata.
Justice P.K. Mahanti earlier.
Again. खाली प्लासिटम टा लास्ट रे पढ़ी दोचे again. It placitum first again, right hand side.
You supply two decisions.
Again.
Both are delivered by me. One in mutation appeal, I have already indicated what is the extent of power. To what extent an appellate authority under mutation manual can go.
Again.
Even section 15 review, I have already decided. To what extent the commissioner can go. If there is already a dispute existing, then it has to be left to be considered by a competent authority. 15B super tahsildar, I have already held in that manner. Then there is, I have also a decision where Mr. Sonok Mishra himself was arguing. I have distinguished a division bench decision of this court. There, I have taken help of Supreme Court decision. What should be the period of limitation in bringing such litigation? What should be period of litigation? Res judicata is one aspect, a very strong ground maybe at this stage. I don't know what he will be submitting. Only hearing you.
My lord, regarding limitation, I want to place, my lord. Section 34 clearly says, Survey Settlement Act, any application, appeal, file after period of limitation will be dismissed, even though defense says there is no
decision kind.
Statute clear.
No, statute goes.
Statute pura clear goes.
Statute re sabu jinso kon operation hochi. Ta pore au writ petition entertain houni. That is statute. So far as statutory authorities are concerned, it's not binding on the 226 courts.
No.
So therefore, don't argue. Don't argue that.
Commissioner
the authorities under that act can no more entertain such application or further application. So therefore,
but today I have got a decision of.
All right, that's all. You find out these three decisions. You are busy probably. Both busy रह जाऊँगी. पिलांग को task करना Court will definitely go into all.
Your lordship is thinking your lordship's time on this side.
All right, yes, Mr. Mishra, now you can start.
Lordship. I filed a short written note, your lordship.
Yes,
Lordship, my first
facts remain undisputed.
Lordship.
There are a previous round of litigation. There is a fresh litigation. Facts also not disputed. Earlier round of litigations were thrashed out till revision, and that revision order is not challenged. Fraud, as he had shown from the pleadings, fraud was also an issue already there in the previous proceeding. Now all right, you argue in your way.
Lordship, my first ground that we have taken is that this writ petition itself is not maintainable, your lordship.
Achha.
Because your lordship, what the person that is Anup Kumar Dheer, it was in his own personal capacity that he had filed this appeal, your lordship. Now he has come in this writ petition via his company. So now the law is very clear that the company and the natural person behind the company are not the same person, your lordship. And in a writ of certiorari, he himself has to come because he, in his own natural capacity, was the appellant in the case. Your Lordship may come to page 45.
So you challenge the locus standi of the party.
My lords, it's not at all maintainable, Your Lordship, because he has filed it through the company. He may be the director of the company, the managing director of the company, but the case, the revision, the appeal, everything, it has been filed by him in his own personal capacity. Your Lordship may come to page 45. That is the genesis of this whole second round of litigation.
So your submission, previous litigations having been fought in his personal capacity.
Lordship, this round of litigation.
Company should not have come.
My lords, previous round of litigation was fought by his seller. This round he has fought himself.
Vendor.
Vendor, Your Lordship.
He is vendor.
My lords.
Vendor sells to individual or to the firm.
They sold it to the firm, Your Lordship. That also Your Lordship may see.
Vendor
Sold
sells
it.
it to firm.
My lords, they've sold it to the petitioner of the.
Then Mr. Mishra, you are to answer previous litigations undisputedly by the vendor.
Lordship.
Now vendor has vanished because vendor has sold in the meantime to the. Now who will be party likely to be affected? Vendor is vanished.
The company, Your Lordship.
Company. So company
Yes.
has come.
But the company was not a party in the lower
May
court
not be,
proceedings.
but who is affecting right now?
The company will get
Alright,
affected.
That's your submission.
But Your Lordship may see, it's a writ of certiorari. So therefore, the parties in the court below have to be appended as a party here. So now Anup Kumar Dheer himself was a party in his own personal capacity. He cannot, through his company, come in a writ petition challenging the order.
Anup Kumar Ji is a director.
He's the
Managing director.
he's the managing director, Your Lordship.
Managing director.
My lords.
Right. So all right, this is a technical issue.
Lordship. Because the revisional order also has been passed against him in his personal capacity, both the orders.
Okay. Sale, there is no dispute. Vendor has sold it to farm.
The company, my lords.
Okay, then.
Lordship. Then my second ground is that res judicata is divided into two parts, Your Lordship. One is of subject matter and other is of parties. Here, Your Lordship, the subject matter of the suit is same, that we are not disputing. However, the parties are different, Your Lordship.
From the perspective of party.
My lords, the parties are different. And now the petitioner has come into the shoes of the vendor. That part is clear, Your Lordship. But the second aspect are the other parties.
Just 1 minute. Party means the petitioner is different. Petitioner was nowhere there.
He was not there.
State is always there.
We were there, Your
One
Lordship.
of the party there.
We were there.
Party petitioner was never a party to.
He was never a party. He is in fact in his own natural person, no way connected to any of the case
law
matter.
is fairly well
Only through his
settled.
company.
But law is fairly well settled. Once the property involved and an adjudication on the issue involved here is already there,
Lordship.
then res judicata will apply.
But again, the subsequent appeal that they have filed, now there is an
Property
existence.
is there.
No, there is an existence.
Property is there.
Lordship is there.
Extent of challenge is also there, same, continuing all through.
Lordship.
Only thing is now the occupier has come.
My lords.
Present dispute is by occupier undertaking the exercise already undertaken earlier and now raises the question of res judicata.
Lordship. But once they have filed an appeal again, so there lies an existence of an appeal that is under the statute. So if there is an existence of an appeal under a statute, so a natural revision will always lie.
Come to next round.
Lordship. Lords, next ground is that since this is they're challenging an appeal order under section 22, a revision under section 32 lies, Your Lordship. So I've quoted a Supreme Court judgment. Your Lordship may come to point C of my written notes.
Statutory provisions, remedies cannot be avoided.
They have not been exhausted yet. Because it has been categorically stated that if it is violation of fundamental rights or principles of natural justice.
But if you will go through those decisions,
Lordship.
you will never find such decision involved res judicata question.
No, this decision is in fact.
So therefore, once res judicata operates,
Lordship.
assume, then no further proceeding is required. No further proceeding is required at all. Because it will take away the initiation of the second round of litigation itself. Why should one go for revision?
But here in the peculiar circumstances of this case, the petitioner himself has initiated the second round of litigation. So once that has, my humble submission is that once that has been instituted under a statute, it will flow through the statute.
Appeal. You say, you talk of appeal.
The second round, your Lordship, appeal case
Mutation
251.
appeal.
My Lords.
Mutation appeal is a requirement for the transition made in the meantime. Who else will come in preparing the record of right or asking for record of right? But it's only the occupier or the purchaser. So he being a purchaser from a rightful owner in a dispute earlier decided, record of right already prepared in favor of vendor, he has the only remedy to come in mutation read together with service settlement provisions.
Yes, he has that right.
Therefore, he has a right, Mr. Mishra.
So therefore, my only humble submission is.
Okay, I take note of this.
My Lords.
So statutory remedy being available cannot be avoided.
Lordship. Now your Lordship may kindly come to Annexure 2. That is the first round of litigation, the final order in the revision.
Yes.
My learned senior has read through the submissions of both the parties, your Lordship. Lordship may kindly come to the findings. Paragraph 7, page number 30. Page 30, your Lordship. 30.
Yes.
Para 7, your Lordship. May I place your Lordship?
Yes, yes.
After examining the details, the additional settlement officer has concluded that the Hattopatta was a valid document to create agricultural tenancy. Secondly, the additional settlement officer has said that Exhibit A, Ekpadiya, produced before him showed that the second digit had been erased. So he placed reliance on the tenant's ledger where the figure is 20 acre 21.76 decimals. He has also taken into consideration the objection of the additional tehsildar that the entry in the tenant's ledger was not attested as required under Rule 21 of the Manual of Tehsil Accounts. So he has admitted that part in his own findings, your Lordship. Then your Lordship may see how he has dealt with it. By the revenue, not attested as required under Rule 21 of the Manual of Tehsil Accounts by the revenue supervisor or the tehsildar, but concluded that for negligence in duties of the tehsildar, the respondent cannot suffer. Lordship, there is no premise, no basis to this finding that there was any negligence on part of the revenue authorities. He has just from the thin air, he has dragged this in and he has put this in.
That event you could have come up in a read.
But Lordship, this
could have come up. You abandoned the.
Is that we have never challenged this, that not disputed.
That cannot help you now.
But the tenant's ledger, Lordship, that they are depending on, that's a void document.
True, this is helping you.
My Lord.
But you could have further hesitated with this observation, the revision should not have been allowed. Or in the words, the revision could have been at least directed to be, the appeal could have been reopened. You did not choose to fight it further.
But your Lordship,
that's an admitted question.
Yes, we have not challenged this further.
Okay.
But even then, your Lordship may kindly consider.
You say once he has come to this judgment cannot be taken to be granted.
Lordship.
And admittedly, the position is this order is not challenged.
That is not challenged.
And for not only the matter did not end there. See, following this, record of right has been prepared. Following this, On preparation of record of right, further sale transaction has been entered into. Following further sale transaction, appeal was obviously the remedy, only remedy available.
Your Lordship, my humble submission is that these are all, they are all, the genesis is the
These are
tenant's
all
ledger.
material. These are all
Lordship, the
material.
genesis is the tenant's ledger, which has never, the original copy has never been produced. Secondly, Your Lordship, that has never been attested, that is accepted by all the parties. And without attesting, as per the Registration Act, it becomes a completely void document. And anything, any order emerging from a void document is a void order itself. Your Lordship may kindly consider this submission, Your Lordship. Because we have admittedly, we have not challenged that. However, that the genesis of that whole order is a void document, Your Lordship.
I find surprise. Your Tahsildar himself has spoiled the case.
Lordship,
your Tahsildar himself has spoiled the case. He had entered into further inquiry. He had given a certificate that there has been transactions and continuation in possession appropriately. He had submitted before the revisional authority.
Yes, that report is there.
That's there. So, all right. You have a decision also on this question. This.
I'll give a copy of the decision, Your Lordship. And my final point, Your Lordship, is that what under Section 5 I proviso of the OEA Act, what the power has been vested with the OEA collector, because this is an estate land, Your Lordship, ex-estate land. So only the OEA collector has the power to grant any rights. The settlement authorities have no such power, Your Lordship. Because that the verification of that patta could be done by the OEA collector, not by the settlement authorities. And moreover, Your Lordship, as per the fraud allegations are concerned, the settlement authorities have no power to conclude whether there has been any fraudulent activities or not. So they should have left it open to the.
What is the development given on the land now?
Lordship, I don't have any
Admitted
instruction.
fact, complete pleading that there has been approval of building plan and a building has come up.
Building, whether it's still existing or not, Lordship.
There is pleading.
I don't have any instruction on that, Lordship.
So therefore, looking to then this should have been blocked. All right. That's your ground, okay. The OA collector rather should have exercised.
Lordship.
OA collectors.
As per Section 5 I proviso, Your Lordship, of the OEA Act.
What is that provision? Deeming. Even somebody, Section 8 probably. Please read OEA Act, Section 8.
Section 8, Your Lord.
OEA Act. Suppose somebody has not applied, then there will be deemed title. There is a prescription for applying. Yeah, filing claims 8A.
8A, Your Lordship, yes.
So far tenant is concerned, 8.1 application does not contemplate filing of any application.
Pardon?
So far section 8.1 tenant is concerned, it does not contemplate filing of any application. It is.
All right. Any other ground?
No, that's all, Your Lordship.
Thank you. Hearing closed. Actually, still it is open for both sides for supplementing decisions. Okay, only decisions.
Again,
Just
technically
give
page 31 annexure 2 रे कमिशनर मध्य कहचंदी जे 5.1 I proceeding ए पर्यंत किछि इनिशिएट हेई नाही लिखिछन से
Page 31.
पेज 31 again 7-8 धाडी परे he has also come to the finding that at no stage the revenue authorities had taken any action under section 5I of the OE Act to cancel the lease or arrange eviction of the respondent from the disputed land.
All right. Hearing concluded. Bag, Mr. Bansidhar Bag, and the other side, Sonok Misra, additional standing counsel. Both sides have also provided the court written note of submission along with citations. Upon a copy, they don't to say decision.
Lordship.
Okay. Which are kept on record. Judgment reserved. Eko dabo OE Act rahibo, OSS rahibo, mutation manual rahibo. Yes, 28. What is this correction per
Saying
pair?
for modification of order dated 17/3/23, my
29
lord.
conversion.
Only one word correction. Para
Yes,
3 of the order.
correction koriba.
Aଜ୍ଞା.
28 to?
Aଜ୍ଞା.
28 correction.
तहसीलदार बासुदेवपुर जगह बालियापाड़ा.
29 भी conversion hobo. Hala. Yes, what is this 2000 read petition?
Account 30.
ये read appeal आसी.
Yes, my lord.
Read
After
appeal आसी
yes.
रही जाओ.
हाँ.
रही जाओ. मु रिटायर ହେଲା ପରେ जी सुनिबे से करिवे.
I filed caveat without informing
Okay,
the writ appeal has
आपको
been.
तो ना बाहर हो.
Not-
सुनानी हबो आपको सुनिबे होला because I had given a
I protected their interest 3-4
Actually,
occasions. They were
My
absent.
lord.
And
सुनानी हबो by some other judge. hala. I have taken a view. If it is interfered, it could have been allowed there even. Why remand? ଯଦି remand ହେଲା ଆଉ ଜଣେ judge କିଏ third judge ନିଅ to decide. Matter stand delisted ହେଲା. Yes.
Next
Yes,
list.
other cases I have completed hearing, therefore I will not undertake any hearing exercise today.
My lord,
Aji
which
shunibi.
date?
No, no, खाली कहूँ
This item 30, my lord, when it will taken up, if not today.
30.
My lord.
नहीं, not today, no, not in my tenure.
କାହିଁ କଣ ଆମେ ଆଜ୍ଞା କଣ କଲୁ ଆପଣ ଅସୁବିଧା
नहीं नहीं ମୁଁ କରିପାରିବିନି ମୁଁ କହୁଛି ଯେ ଶୁଣନ୍ତୁ it is better I have made up some mind. I have given a judgment. Now division bench says no, that judgment is not correct. Let a third judge decide. ମୁଁ ଆଉ decide କଲେ ମୁଁ ସେଇ decision ନେବି. Therefore again division bench will interfere. Then what do how do you get benefit?
So posted after vacation.
After vacation.
ନାଇଁ ମାନେ
After my departure.
ଏମିତି ପୁରା ଆପଣ ଏମିତି
delist କରିଦେଇଛି ଆସିବ.
some chances you are getting to come before your mind.
ତା ଉପରେ
Very occasional.
Next time your lordship can dispose of that matter.
I can dispose all matters.
No, ଗୋଟେ line dispose of ହେଇଯିବ. ଯେ ମୁଁ headquarter ର change ପାଇଁ କା ଆସିଛି. Let them reconsider my.
Reconsiderably interfere କରିବାକୁ ହବ. Reconsiderably interfere କରିବାକୁ ପଡିବ in the impugned order. Please wait. ଆସିବ ଏ matter ସବୁ ଆସିବ. It is
I
not
have got a
delisted.
small matter.
Only one item is delisted. बाकी
So I have got a small matter, item number 35.
23 matters will go out of list.
I have got a small matter, item number 35, which was also before, my lord, the last time it was heard.
35.
My lord, I am appearing for the opposite party. My lord, I have also filed an application for vacation of stay. My lord, my petrol pump has been stayed by my counterpart, who is having a petrol pump.
Okay, ଶୁଣନ୍ତୁ ଆଜି ଶୁଣି ପାରିବିନି ମୁଁ. ମୋର time ନାହିଁ. I have time constraint today. ଦିଟା matter ଗୋଟେ ଦିନକୁ ଦେଇଦିଅ.
Interim order.
Item 37 election matter.
Interim order election matter କଣ କରିବି କୁହନ୍ତୁ. ମୋର ଏବେ time ନାହିଁ. ଆପଣଙ୍କୁ କହୁଛି ଦିଟା matter କୁ ଗୋଟେ ଦିନ
Covered by my lord.
Covered by my lords.
No, no, no,
Covered by
another
some
judgment is
more
there.
election ପୁଣି reserve ରହିଛି ବିଦ୍ୟାଧର ମିଶ୍ର କରୁଥିଲେ
Lordship, I will file the rejoinder in this
ଗୋଟେ
case.
ଦେଲେ ତ ପୁଣି ଆଉ ଗୋଟେ କରିବି
Yes, yes.
so therefore ମୋ ହାତରେ ବର୍ତ୍ତମାନ 3ଟା ଜଜମେଣ୍ଟ ରିଜର୍ଭ ରହିଲାଣି
हम ସେଥିରେ ଟିକେ rejoinder file କର ସେଥିରେ 37
ଆଉଟ ଅଫ ଲିଷ୍ଟ ଯାଉଛି କେତେ ଆଇଟମ ଆପଣଙ୍କର
37 ବୋଲ
37.
37 ତ ଆଉଟ ଅଫ ଲିଷ୍ଟ ଥିବ
yes
And next week, as election matter, your lordship, they have
37 ଟା ଆପଣ ସେଇ
in the stage of judgment only.
I'll file rejoinder.
election matter rejoinder କଣ where is the scope for
Since he has filed the counter
counter forward
and he has filed the new facts.
counter forward दवा आगे
Yes.
election dispute रे where is the scope for further pleading here
Yes.
এটা ধଳ ଏଗୁଡା କେ ଦିଦିଟା matter କାଟିଟା ଆସିବ
Sorry.
next day onwards
Item 40 ଟା 23 ର matter.
40 withdraw କରିବେ
ଆଜ୍ଞା ଗ୍ରାମ ପଞ୍ଚାୟତ ର ହେଡକ୍ୱାର୍ଟର କୋଉଠି ହବ ଆପଣ ପାଞ୍ଚଟା ଜାତି
କରୁଥିଲେ ମୁଁ କହୁଛି ଆସିବ ସବୁ ଦିଦିଟା matter
ନାଇଁ ମୁଁ ଭାବିଲି ଡିଲିଟ ହେଇଯିବ କହିଲେ ତ ସେଇଥିରେ କହିଲି
Senior
39 item.
39 ଏଇ ଦିଦିଟା matter ରେ କରିବା ଗୋଟେ ଗୋଟେ
So 39 ଟା actually connected matter with Justice Panigrahi and they said that it is assigned to them, but in that court.
ତାହେଲେ ଏଟା ଯାଉ ସେଠି ପଳଉ
Sir, interim order is there.
find out the assignment and place it accordingly
Sir, the interim order is there.
interim order to continue
Right.
unless it is vacated by appropriate
See, aji gote thila au gote connected matter, he has fixed it to 22nd.
the notice that connected matter is already in the assignment of justice honorable justice
That matter, we are also appearing.
there is no hesitation in bar that this matter can
By
also
guarantee.
be heard by that way
ସେଟା 22 ଅଗଷ୍ଟ କୁ ଯାଇଛି ଆଜି ଥିଲା ସେଇଠି ସେ ଅନୁଭବ
so se number ta dei paribe ka
ହଁ ସାର୍ ସାଙ୍ଗେ ସାଙ୍ଗେ ଦେଇଦେବି
debe slip re hala
ସାର୍ ସେଟା
Right,
ହଉଛି
so and so, hala. The matter has been posted to 22nd of August. 22nd of August. Mr. Mishra, 22nd of August. 22nd of August. ଆଉ ଦି ସପ୍ତାହ ଘୁଞ୍ଚେଇ ଦେଲେନି ଗଲା ଆଉ ଦରକାର ପଡିନଥାନ୍ତା ଏ ଅବଜରଭେସନ
ସେଟା 20164 of 2023.
ask your associate to give it
My lord, in this,
the registry to
my lord, Mr.
Friends are appearing.
Yes, I am for open number 4 and 5 for State Bank. Yes, it is there in the list. My lord.
registry to
The interim order to continue.
list it accordingly interim order to continue
So that interim order to continue.
continue
Item number 38, Your Lordship, item number 38.
38
No, no, so I've already received a counter which the BD has filed. I need some time to file a rejoinder.
development authority matter
Again.
so
I need some,
ଆର ସପ୍ତାହରେ ଆସିଲେ ହବନି
no, no, I just need some time to file a rejoinder.
So here in this case,
how much time you want
At least 2 weeks, my lord, I have to
2
take
weeks
instructions.
okay Sri Koro Nanet
38.
senior counsel 2 weeks time for filing a rejoinder ala dita ka matter re rejoinder karibe
Intact matter. Good, dita
no,
counter diya hai.
last
That
dita
is-
counter diyaji first or
in
counter
both the matter the counter affidavit filed by the development authority
Did your best.
matter will be placed 3 weeks after
Did your best.
so auction process has been stayed my lords.
मरा हुआ किसको जो-
2
auction
weeks
process-
maguchun se kon kare 10 days dei diyo 2 weeks after kara interim order rahi jaichi continue karibo process complete ହେଇନି
ନା ପ୍ରୋସେସ କମ୍ପ୍ଲିଟ ହେଇଯାଇଛି ତାପରେ ଆସୁଛନ୍ତି କହିବା ପାଇଁ ଯେ ନାଇଁ ଆମେ ଟଙ୍କା ଦେଇଦେବୁ ଆପଣ ଡିଫଲ୍ଟର
all right
Interim order to continue.
interim order to continue
Obligement.
34 matter. Sir, my lord, item 34, a noting is there ki counter has been filed by opposition 2 and 5. I have not received the copy. Interim order to continue, my lord.
देखी दे दियो
Interim order to continue.
हाँ interim order सब जोड़ा
Okay.
ଅଛି interim order continue अब मते न कोई की रिक्वेस्ट कलेनी स्टेट को कौन कर परिबेनी